with regard to item number 52, I have filed an IA, my lord. So, my lord, it may be permitted to be called for, my lord. My lord, one another pair along with it, my lord, can this matter be taken up at 2?
Item
52 of supply 52. My lord, that is with regard to the SOCOS that came that day, with regard to the T state, my lord.
Okay.
Must oblige, my lord.
Made with your lordship. So far as the item number 24 is concerned, my lord. In this matter, my lord, they have filed affidavit. I need to file reply. I have already informed.
Wait. We'll have to see here. What's the cause of action?
Cause of action is, my lord, that's why, my lord, because
That's a
Agreement-
question of law. It's not a question of
my
fact.
lord, the agreement was executed at Guwahati, my lord.
Okay.
All these things, documents are required to be placed before your lordship. That's why. Next
So,
week or
why?
any date, my lord.
Why? Just to say that your basic case is that the agreement was signed there.
Agreement was signed
That's-
here.
that's the
There
only
is a
thing.
clause here. Jurisdiction is also confined in the agreement that it has to be Guwahati, my lord. So all this that I will place before your lordship. Next week, your lordship. Next week or day after 2 weeks. my lord.
Next week. Right, Mr.
A. Goyal, my
A. Goyal, learned counsel for the petitioner, submits that he will be filing affidavit in reply within a week. Accordingly, leave this matter in the next week. In the next week.
lord.
May I please your lordship?
Deep law.
May I please your lordship? With the consent of the attaché, I beg to mention item number 36, my lord.
Yes.
Only adjourned for a week, lordship.
Why?
Lordship, in this case, I'm in lead by the Mr. Ken Sodhi, sir. He is in lead, lordship.
Who is Mr. K. Chaudhary is?
Ken Sodhi, sir.
Yes.
Senior counsel.
What about him?
He is in leave, lordship.
Okay, right. Adjournment prayer has been made on behalf of Mr. K. Chaudhary, learned senior counsel. Praise the Lord. This is the matter after review.
Hello. May I please your lordship? Lordship, I beg to mention item number 1, lordship.
One. Yes.
In this matter, we are being led by senior counsel, Mr. P.K. Goswami.
Mr. P.K. Goswami. So,
He could not come down to Guwahati due to some flight issues. Lord. After a week, my lord.
when?
After a week, my lord.
What is your case here? Please, this is not a question about your senator. What is your case?
Lordship, this is the lordship disobedience of judgment and order dated 26/8/2022 passed by this court, lordship.
26/8?
2022.
If it's a disobedience, why don't you file a contempt?
This is a contempt.
Acha, okay. This is a contempt, yes. No, the issue is whether the quota has been reduced. Show us where the quota has been reduced.
Reduced, lordship.
Where has it been reduced?
We have annexed the documents and we were supposed to adduce some supplementary documents also. So some development is also going on.
No. Just give me the. You wait. We'll see. Item 1, we'll see. Yes.
Right, please, your lordship. I beg to mention, lordship, item number 4 of today's this panel.
Yes.
That, my lord, as per instruction of the client, I am not pressing, man.
Not proceed.
Sir, I am appearing for number 6, my lord.
Huh?
I am appearing for private number 6.
Okay. Mr. What is your name?
FKR Ahmed, my lord. So I filed, I'm newly filed a welcome, my lord.
FKR Ahmed, appearing for the petitioner. They had prayed for, he had prayed for withdrawal. It was not being done by the earlier council.
It is serious, then I don't want to, my lord, trouble in this council, my lord. If I reveal everything, you will be in problem, my lord. That's why, my lord, I want to withdraw, my lord.
Right, Mr. FKR Ahmed, learned counsel, just give me item 4. Item 4.
Because earlier similar case filed with some false document that was withdrawn, my lord. Again, with different person, again,
No, no.
same.
Counsel for the petitioner submits that.
Very serious allegation, my lord. I have seen copy stuff.
No, submits that. The petitioner had asked his earlier counsel to withdraw the writ petition. So, however, as the same was not being done by the earlier counsel for the petitioner. The petitioner has now approached him and has accordingly submitted an affidavit for withdrawal of the writ petition on 2/2/2024. Mr.
AK Talukdar.
A.K. Talukdar appears for the,
Highway test number 6.
for the respondent number 6. Who appears for the others? Mr. J. Handig appears for respondent number 1 to 3. 1 to 3, while Mr. K. Gogoi appears for respondent number 4 and 5. On the prayer of Mr. F.K.R. Ahmed, learned counsel for the petitioner, the writ petition dismissed as withdrawn.
May I pray your lordship? My lord,
Yes,
I beg to mention two writ petition to be listed tomorrow, my lord, for withdrawal.
okay.
I need to mention for listing a writ petition in any date of this lordship.
No, what is this? What? New matter?
2023 matter about admission column lordship.
Huh? When was it last listed?
Last listed last week, last month. lordship.
Oh, no hurry with this.
Please, Your Lordship.
You go to the registry and ask. Yes,
Lordship, item number 49 to 51
49
to 51
to 51.
are three tender matters that Your Lordship had heard last week.
Okay, that distributor
Your
thing.
Lordship can upgrade the matter, to dispose of the matter, whichever order Your Lordship. expect. If it-
Mr.
Your Lordship.
Everybody wants
Yes,
upgradation.
yes, I understand, Your Lordship, but there's some commercial interest involved also.
So what? Commercial interest will always be there.
I will leave it to Your Lordship, I'll leave it to Your Lordship.
You wait, we'll see how it can be done. The other matters also will try and
Yes,
fast pace the cases, let's see.
I'm grateful, Your Lordship.
May I please, your lordship, with the consent of the other side, I beg to mention item number 11 of the daily cause list for adjournment, lordship.
Right?
Lordship, there is some personal difficulty of the senior counsel. Lordship, kindly adjourn the matter for today and kindly fix any date in the next week, lordship.
Why?
Lordship, there is some personal difficulty of the senior counsel.
Who is the senior counsel?
Nirupama Soikia.
Right, on the prayer for adjournment made by Mrs. N. Sakia, who is alleged, who is supposedly having some personal difficulty.
Lordship, kindly fix any date in the next week.
This is the matter after a week. Next.
Obliged.
May I please, Lordship? I beg to mention item number 22. With the consent of other side, it may be fixed. 4 weeks time may be granted for filing reply.
For filing?
Final reply.
Huh?
Reply to the petitioner.
Why, you're the petitioner?
I'm the respondent.
I am the petitioner, my lord. Will file actually opposition. I am for the petition.
Yeah, why don't you want the arbitration to take place?
There's on the ground of limitation, there is
On the ground of?
limitation.
Where's
There will be
where's the
time.
question of limitation in an arbitration matter?
Already, it has been time barred.
Time bar.
We'll file objection.
On the prayer for adjournment, on the prayer of Mr.
KL Gupta.
K.
KL Gupta.
K.L. Gupta, learned counsel for the respondents, who submit that he will be filing affidavit in opposition within
4 weeks.
4 weeks.
4 weeks.
No.
Corporation matter,
Huh?
instruction is to be taken. Lordship.
What instruction? There's an arbitration clause or not?
Arbitration clause is there.
Is there a dispute or not?
Yes, ma'am.
Yes,
Then what remains?
still there some. technical-
What?
Still, some time may be given, sir.
For-
for
why?
filing reply.
Okay, this 1 week's time is granted to file no objection. This is the matter. 1 week time is to file no objection. This is the matter after the week.
My lord, may I pray for listing a admission matter in next week?
Now give a date. We take a date from the registry.
May it please your lordship. Lordship, I'd like to pray for listing of a fresh writ petition for tomorrow, lordship.
Tomorrow.
Yes, lordship.
Why?
Lordship, it is a little urgent. We have filed. a-
What is the urgency?
Lordship, this is with regard to the off-roading of the 200 private city buses, Lordship. There are certain decisions which are in the offing. If it gets passed, our writ petition will become infructuous, Lordship.
What is the urgency? What is the problem?
Lordship, 200 city buses have been off-roaded by the government.
Ah.
These people are sitting outside, and as of now, Lordship,
It is,
Sitting outside where?
they are not on road, they are not lying on the road.
So?
They have been removed, Lordship.
So who are you?
I'm the petitioner, I'm for the 203 buses, Lordship.
So you're challenging a decision of the
Yes,
government
Lordship.
after tomorrow.
Lordship, kindly tomorrow, Lordship.
Why?
Lordship, there are certain decisions which are there in the offing, Lordship.
In the offing, it's
Yes,
not
Lord.
there, no?
It's not there, but
Then-
it might affect our petition, Lordship.
I don't, we cannot.
But tomorrow, kindly, Lordship,
You please tell me the urgency, madam. You just cannot say something is very urgent without giving a definite clue as to what is the urgency.
Lordship, then the day after.
Everything.
Wait, please, your lordship, lordship, I beg to mention item number 20, your lordship,
Yes,
for a week, your lordship. Adjourned for a week.
20, I think there is a,
Lordship, we're putting a BC request, he has some, conducting council has some inconvenience, your lordship. Without asking me.
you're for whom?
I'm for the petitioner, your lordship.
You're for the petitioner.
Otherwise also, Lordship, issue is pending report on our apex court for consideration in the constitutional bench. Central Railways Organization case, Lordship.
No, anyway, who has asked for the VC link?
Lordship.
Petitioner
Lordship,
or petitioner? You're appearing for the petitioner.
lordship,
Now petitioner wants the adjournment.
lordship.
So which one is he pressing? He wants the VC link or he wants adjournment?
Adjournment, your lordship.
Okay. On the prayer for adjournment made on behalf of Mr.
And Gautam, your lordship.
N.
Gautam, your lordship.
Then Gautam, then also for the petition, this is the matter after.
A week.
Lordship, I beg to mention item 23, Your Lordship.
Yes,
This matter may be adjourned for a week, Your Lordship.
why?
This is regarding the payment of materials bills, Your Lordship.
No, you wait. You wait. You're for the petitioner.
Petition.
You wait. You see one thing, we can dispose it of here itself. They have said that they have not issued any supply order.
But part payment has been made, Your Lordship.
So what? But where is the, now part payment has been made? How do, now they have said that no supply, this is a disputed question of fact. You go to the civil court. Where is the question?
The matter may be this.
Huh? No adjournment, no adjournment. What is your name?
K. Mira, Your Lordship.
Huh?
K. Mira, Your Lordship.
Okay, Mira, you wait. If you don't wait, we are going to dispose of anyway.
May I have your lordship, lordship, I recommend item number 34 and 37. 37. This matter, when a similar matter is pending with his honorable court, wherein the records were called for. So, we have some difficulty because you cannot file the affidavit because the record is with the court in another matter. I will give the number, let it come after 2 weeks.
34 and 37.
37.
Wait. Who is for 34 and 37?
Petitioner is as both I had.
You wait.
My lord.
May I please, my lord? I beg to mention item now 47, my lord. We have filed an affidavit, my lord, that will be called for and check with the record. my lord.
Huh?
Item now 47.
Yes,
my lord.
what do you want?
We have filed an affidavit, my lord, that may be called for. Okay.
Please, Your Lordship, I would like to mention for listing of writ petition. It was last listed on 17 November 2023.
What give a date?
May it please Your Lordship, I'd like to mention an item for listing, Your Lordship, for admissions. Matter pertains to settlement of a cow market, and settlement period gets over on 30th of June 2024.
When was it last listed?
Last listed on 17th of October, Your Lordship. 2023. Next. Much obliged.
Yes. Where is the violation?
Lordship, page 29, lordship. And the operative portion is page 33.
Page?
33, lordship.
There?
Para 10, 11. lordship.
There? Yes, so shall not curtail the quantity.
Lordship,
What is the quantity?
440 metric. lordship.
440. Now, where does it show that you have been
If
getting
lordship
less?
Come to page
Huh?
46, my lord.
What is it?
We have issued a letter to the managing director, lord. Page 46, annexure D. This is the quantity provided to us.
Where are you?
Lordship, Large specialty, 2 and 3. Two, three,
How much are you supposed to get?
440 metric,
440
metric ton
metric tons per month?
Right.
Per month or per year?
per month.
Per month. And your contract is till which period?
Lordship,
Your contract is till which period?
Lordship till, that contract was for 1 year, Lordship.
Yes, from which period to which period?
That agreement is not with me, Lordship.
Then how do we know whether, how do we
It's in
know?
the original lead petition, Lordship. It's
So-
in the original lead.
So unless you can show that there has been a violation
Right.
of the orders of this court during the validity of that agreement period, how can you say that there has been a violation? How can you prove?
If Lordship permits me 1 or 2 days, Lordship, I'll check.
Huh?
If Lordship permits 1 or 2 days, I'll check.
Right, on the prayer of the petition council, list the matter day after tomorrow.
Deeply.
This matter was earlier dismissed for default and my lord said restored it loss. Today also they have not appealed. Otherwise, lordship, the order they have executed, that order was also lordship stayed in another writ petition lordship, filed by the lordship IPC lordship.
So these are dismissed.
So this was dismissed for default and it was also restored lordship. And regarding lordship, the honorable court's query is lordship whether this petition is maintainable or not. That part the petitioner had to lordship reply.
We will dismiss it again if they are not coming. Let them file another restoration, will impose heavy cost. This is not the way to, right? No one appears on behalf of the petition. So, this writ petition had been dismissed for non-prosecution. Right, order dated 17/11/2023. However, the petitioner thereafter filed an application for restoration of the writ petition. While miss case number 90 of 2023, which was allowed by order dated 22/1/2024. As stated earlier, no one appears on behalf of the petitioner.
Lordship, last time indicate one thing, causeless lordship, the petitioner's counsel parties blank lordship.
Oh,
Probably that reason lordship they are.
okay, right.
So lordship may give one chance.
Right. However, on perusing the cause list, it is seen that it is seen that the name of the petitioner's counsel is not reflected in the cause list. Accordingly, the matter is adjourned till next date. This is the matter be listed on Monday. Registry to reflect the name of the petitioner's counsel in the cause list.
Wait, your lordship. Madam, may I kindly have a look the last order of this honorable court. Last order of this honorable.
Lordship,
What is the amount claimed by you?
Lordship, let them file affidavit, Lordship.
It's not a question of,
already-
Mr. Counsel, there, you see, you have to make a claim.
Lordship.
You cannot just ask this court to do a roving inquiry on your behalf. If you want, what you can do is, you withdraw the writ petition and file afresh, but you give the amount.
I'll file one IA Lordship.
IA for what?
Additional affidavit.
Mr. Council, this has been allowed to you 2 months back. This time, you have not done it.
I may
Why
be
should I
given
allow?
last opportunity for 1 week. May be granted. I'll file additional affidavit citing the amount
And the bill?
and the.
Where is the
bill?
bill that you have submitted? Where is the bill that you have submitted to the authorities?
Actually, Lordship, I have submitted one numbers of the vehicles, Lordship.
Mr. Council, you have to submit bills.
Lordship,
Where are the bills?
I'll submit, Lordship. I may be given one opportunity.
We'll list it on Friday. If you don't submit by then, I'm dismissing it. You cannot file a writ petition like this.
Lordship. I'll file by Friday.
Mr. T.K. Mishra, learned counsel for the petitioner, prays for a direction for release of bills pertaining to hiring of his vehicles by the Commissioner of Police, Guwahati. Pusta however, neither has the petitioner stated the amount that is to be paid by the respondents, and neither has he annexed any bill pertaining to the amount claimed, pertaining to any amount claimed by the petitioner. List the matter on so and so 9, by which date an additional affidavit should be filed by the petitioner regarding the above.
Look.
If the same is not filed, the matter will be decided on the basis of the materials on record.
I'm obliged.
Obliged.
When on the last decision, they are directly taking instruction.
That's it. As per
Yes,
As per my instruction, your lordship, it is FMP work, your lordship.
Huh?
FMP work, your lordship.
so
Jal Shakti is the necessary party because central share is, I have the amount, your lordship. Lordship, estimated amount is 1210.9 lakhs, your lordship.
12.9.
1210.9 lakhs, your
Ah.
lordship. There, central share is, lordship, 1006.23 lakhs, your lordship.
1006.23.
Yes, sir. Out of that, we have received only 440 lakhs, your lordship. That we have paid and balance amount, lordship, 566.23 lakhs, your lordship.
566.
0.23 lakhs. So, lordship, may I pray petitioner may be allowed to implement Jal Shakti as party respondent so that, lordship. Because we
Is
could
it
not-
going to help?
Yes, your lordship, because we could not, without receiving money from them, lordship, we could not release your lordship.
But I think there was a order passed by this court earlier in a batch of writ petitions.
Yes, your lordship.
Now, those batch of writ petitions, has it helped? That those order passed in those batch of writ petitions, has it helped you to get the money?
Lordship, exactly, then we have to know the position of the central government.
Madam, please do not digress. There was a batch of writ petitions
Yes, your lordship.
which were disposed of by this court for payment, where the central government was there also.
Yes.
And certain time period was given. So has the central government complied with the directions passed therein? So how will it help?
Lordship, our hands are also tied, your lordship. We could not pay your lordship because from where state will pay your lordship? We have already paid our share, your lordship. Our share is only 2.4.67 lakhs, your lordship. That's we have paid, your lordship.
Anyway, what to do, madam? I think you'll have to make, yes,
I will make them party, my lord.
you have to make them party.
My lord, petitioner executed the work, my lord, in the year 2012, my lord.
But what to do? You see that the issue is if the central government share is to be paid, then you have to make a claim against them. Only problem is I don't know how it will help. Because in similar matters, where the central government was a party, this court had already passed directions. Still they don't take. Maybe we'll have to call the central government secretary or whatever. I don't know. Right.
So after 1 week, my lord, I will make them party, my lord.
or best, instead of, you'll have to make amendment. Instead of that, you withdraw and you file afresh. It becomes easier, I think. Otherwise, amendment, and you've got to file amended writ petition, you know?
Right.
Ms. S. Prithia, learned counsel for the petitioner submits that she may be allowed to withdraw the writ petition with liberty to file afresh, in as much as she would like to make the Jal Shakti, Jal Shakti, Union of India, Union of India as a party. Miss
Adeka,
R. Deka,
for water resources.
Standing Council of Water Resource Department, submits that she has got no objection to the prayer of the petitioner. Accordingly, the prayer of the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn, with liberty as paid for.
Item 6.
May I please your lordship? Lordship, instruction not received. Earlier, Mr. P. Nayak was appeared.
What instruction?
What was directed to receive instructions?
The liability statement is page number 12, Lordship.
Just a minute.
One week may given.
You are only asking for time, for submission sake, that's all. Where is that letter?
Lordship, page number 12 is the RTI reply, Lordship, admitting its
Okay, right.
liability statement.
Last court date, Mr. Nayak was informed that if no instruction was forthcoming, we'll have to dispose of the matter on the basis of the materials on record. So let the chief engineer make a verification.
Verification already RTI, they are.
But then they are saying that this verification has been done by the assistant executive engineer. It should be done by the chief engineer. That's what they want. The same thing. They say it will be done by executive engineer and they have to just approve it, basically. So we'll do it as they want it. How does it matter? Any problem with that, madam?
No.
Ms. K.K. Chaudhary, learned counsel for the petitioner. Do you take this first paragraph, last order? Miss, what is your name?
M. Das.
M. Das. Standing counsel.
Standing Council.
Learned standing counsel, PWD. Submits that the admitted liability. No, submits that the verification undertaken by the assistant executive engineer bracket T/C backlogs by letter dated 19/12/2023 would have to be verified by the chief engineer PWD Road, Assam, who is the respondent number 2. Yes, sir. Next para. I have heard the learned counsel for the parties, and on perusing the earlier order passed by this court on 29/1/2024, I find that the learned standing counsel PWD had been granted time to obtain instructions from the respondent number 2, whether the liability reflected in the letter dated 19/12/23 issued by the respondent number 5 was an admitted amount. This court, while the order dated 29/1/2024 had also stated that in the event of no instruction being forthcoming on the above query, the court may dispose of the matter on the basis of the materials available on record. Full stop. Next paragraph. On noticing the fact that the respondent number 5 has admitted the liability of the respondents with respect to the unpaid bills of the petitioner. This court is of the view that the same would have to be would have to be verified by the respondent number 2 also. And approval has to be given by this, and approval has to be given by the respondent number 2, if the stated amount is correct. Accordingly, the respondents, especially the respondent number 5, is directed to re-verify the liability of the respondents as reflected in the letter dated 19/12/2023, bracket annexure 1, right, Lou? And take a decision on the same within a period of 2 months from the date of receipt of a copy of this order, along with a copy of the writ petition. In the event of the respondents admitting the liability of admitting their liability in respect of the unpaid bills of the petitioner, the admitted amount should be paid to the petitioner within a further period of 2 months. The writ petition is accordingly disposed of. Okay? So we dispose of in terms of the earlier order.
Central government.
Yes.
Also, in this matter, also we have not received money from the central government.
Whether you receive or not, there is already a order which is covering this case.
Also, today is the first day. May I
How does it
say,
matter whether it's the first day or the third day?
in this matter, we have to take instruction. Your Lord.
What instructions? What instructions will you take?
What is the position, Your Lord?
The position is you have not paid the money. And the thing is that as per, you come to page 19. So this case will cover it. It's similar. Correct. So what remains? So we'll dispose of in this line only. Correct. Heard, Miss
See, Deka.
C. Dekha, learned counsel for the petitioner, who submits that the petitioner had executed contractual work under the scheme formulated by the Ministry of Jal Shakti.
Yes.
Ministry of Jal Shakti,
Just up here.
Government of India, in consultation with the Government of Assam through the Water Resource Department, named as Flood Management and Border Areas Program. What is the amount payable?
Amount in Lordship, page number 27.
27. How much?
3,50,863.
Where do you get 3 lakhs? 35 lakhs, madam.
35.
And next para, the petitions council submits that after completion of the contract work, the state respondents made part payment of the contractual bills of the petitioner. Full stop. However, the petitioner was not paid the remaining balance amount of rupees 35,08,637 as reflected in the liability statement made by the respondents number 7, made by the respondent number 7. And the accounts officer, Moregon Water Resource Division, Moregon. First up. The petitioner's counsel submits that similarly situated persons had approached this court while numerous cases, the leading case being WPC 4734/2024. He submits that while order dated 27/9/2022 passed in the above cases, including 4734/2021, this court had directed, had given certain directions for the procedure to be followed in paying the pending contractual bills of the petitioners therein. So she submits that similar directions may be passed in this case. Stop. Next para. Miss
R Decca,
R. Dekha, learned counsel for
water issue.
the Water Resource Department, Government of Assam, Mr. G. Pegu for respondent number 1. Mr. G. Pegu, CGC for respondent number 1. And name. Mr. R. K. Talukdar, appearing on behalf of Mr. Respondent number 4. Submit that. That's all. Submit that they have got no objection to the prayer made by the petitioner's counsel, provided the respondents make a re-verification as to whether the petitioner had undertaken the contract works, and if pending bills were still, and if there were, and if pending, if there still, and if there were liabilities against the petitioner's contractual bills. Next, please. In view of the consent of the parties, this court directs the Water Resource Department to re-verify as to whether the petitioner had undertaken contractual works in terms of the liability statement which has been issued by the Executive Engineer, Moregon Water Resource Division, Moregon. Bracket page 27 of the petition, and come to a come and take a decision as to whether there are any pending bills against the petitioner. Full stop. In the event, full stop. In the event, the Water Resource Division, Government of Assam, finds that Water Resource Division Moricom, find that there are pending dues against the petitioner's bills, comma, the directions passed provide order dated 27/9/22 in WPC 4734/2021 should be followed for payment of the pending dues. So, sir, the directions passed in the order dated 27/9/22 in WPC 4734/2021 is to the following effect. Page 23, 1, 2, 3. Okay. The writ petition is accordingly disposed of.
So I'm appearing for respondent number 6 as KVA to launcher.
What is your case out here?
In this case, I have challenged the clause 10 of NIT dated 29/4/2023. Issued by the Vadodara Anshalik Panchayat for settlement of market. In this case, that NIT was earlier challenged. Intending tender.
Huh?
So a settlement process has already culminated into a settlement order in his favor, set aside by a honorable court judgment, this honorable court judgment, which is under appeal, wherein a status quo order has been passed.
Okay.
The judgment has not been stayed. Status quo as on today was been passed.
Okay, so his
Now he comes before the honorable court challenging the terms of that NIT, wherein he participated and he was a beneficiary to that. Because that will be now somehow helping him.
no. There was a NIT.
There was an NIT
He participated,
settled
in his favor,
in his favor,
Ah.
challenged,
by somebody else,
yes,
and
aside.
set aside. So he
Also-
challenged, he goes in appeal
Status
against
quo
the
order.
status quo order. So his settlement is in limbo, basically.
Yes,
So he's not looking after the market.
yes.
Yes.
Now he comes up with this fresh
And
petition
challenges the conditions, terms and conditions of the NIT.
of the NIT today.
Because
This is the position.
the
And I am
Yes,
one of the bidders. I had filed a KVA against that NIT. Therefore, I'm now here. I've made a party also. I'm here.
clause 10.
I'm
of
also
the
neither
NIT
here, neither there.
Huh?
Clause 10, regarding clause 10 of the NIT, there are two divergent views of the court in advance of this one. One court held that earlier,
Mr. Counsel, if all these issues are before the DB, why don't you go to the DB?
It's not open
the-
before this.
This court, how can we go into that?
because clause
You see,
clause 10 was not challenged in the earlier writ petition,
so how does it matter?
because
But what does clause 10 say?
It's not better.
yes, Lordship may kindly turn to page 26 . It starts from 25, then close 20, page 26, close 10.
Yes,
The tender of all bazaar houses also offering highest bid price will be considered for settlement. If the tenderer offering highest price does not include the relevant papers and documents except court fee and earnest money, she will be given 3 days time for submission of such papers and documents. And if he is fails to submit the papers and documents within the specified period of 3 days, his tender will be cancelled and his.
okay, now just a minute, NIT was issued, you're the highest tenderer? Not the highest,
Not the highest, he's the
so not the highest.
third highest.
Okay, so the person who challenged your settlement was the highest tenderer, is it?
Lordship,
That is why he's challenging this.
some
clause.
different pictures are there. May I
Then that close was state earlier state by the court. That is.
There was stayed in some other case.
Yes,
Huh.
in the page 36 million,
Yeah.
close 10 of the NIT was
Stayed in some other case.
Yes,
Then,
then it was stayed. Subsequently, since the authority was restrained from taking reports of close 10, so settlement was made in my favor. As
Okay.
tender.
then,
But that settlement was set aside.
so,
So the close 10, my challenge before this honorable court, the close 10 on the ground that it is a violation of Article 14, and it is held by the earlier coordinator.
why? The very object of an NIT for settlement of a market is to get the highest bid. That is the main objective. Why,
It was defective.
what? Why is it
Defective.
defective?
Defective means because clause 10 allows the tenderer to submit the documents after submitting it.
Okay, so to submit what? To submit what document?
The relevant documents which he did not submit at the time of filing tender.
Okay. So in this case, the petitioner, the writ petition in which, the writ petition which has been allowed,
My lord.
he was the highest, but he did not submit the document.
Yes, ma'am. So, but another coordinator bench, in spite of the interim order, taking view that since it is the authority, so my requisition was my settlement was. So, my something let the matter meet in the before after
No case.
otherwise, this matter may be listed along with read appeal.
No.
Because clause 10 was earlier was not challenged. I have challenged the clause 10 of the NIT because it is illegal. This honorable bench I have judgment.
Lordship, this particular clause then was challenged in the last year also, my lord. Thereafter, that appeal has been filed. This is the appeal, my lord, that against that order, my lord.
Which order?
The clause 10 challenged order.
Oh, that,
Yes, Lordship may kindly come to paragraph 10, my lord.
yes,
Paragraph 10, yes. This is the appeal, my lord,
yes.
filed by one petitioner of that, my lord, case. Paragraph 10, may I read, my lord? Paragraph 10. Yes. From the pleadings made in the writ petition and from the impugned order, it is clear that the petitioner, without raising any challenge to the offending clause of the NIT, the participated in the tender process in respect of two markets in question, and when he became unsuccessful, turned around and challenged the clause 10 of the tender. The law is well settled that when a tenderer participates in a tender process without objection and subsequently found to be not successful, a challenge to the process is precluded. Such a tender cannot be allowed to turn around and contended that the process was unfair by virtue of existence of clause in the NIT. This is the same situation in this case, my lord. Before
Only one,
participating, he didn't challenge. Now he is challenging, my lord.
only one question.
My lord.
Why was he selected and not the highest tender?
Because, my lord, one of the bidder, my lord, of another market, my lord, challenged the clause 10 before participating. During that period, that was stayed, my lord. Lordship may kindly come to page 86.
So that was state, so
For time being, that was withdrawn later on.
be that as it may.
Yes.
Why was he selected?
He selected because that effect of clause 10 was not there at that time.
So that person who
Yes.
should have been given the bid actually in the first place did not submit some document.
Yes, my lord. That is a.
Because of that.
Yes, sir. Lordship may kindly come to page 86, my lord. His settlement order.
No,
86.
no,
Page 86
just a
for-
minute, just a minute.
My lord. Page 86 will clear everything, my lord.
Yes.
Page 86, my lord. The last paragraph, my lord. However, these settlements will be dependent on the final order of the honorable court in WPC so and so. This is the case, my lord, where clause 10 was stayed, my lord. For
But
time
this
being.
is not 3325. Where is 3325?
That was earlier judgment, my lord. I have submitted that particular clause 10 was challenged in the last year also. That division.
Where
bench
is the order passed in WPC 3325?
I have an
It is annexed, my lord.
36 million.
36. Initially, that was stayed, my lord, as an interim manner. Later on, the petitioner withdrew that writ petition, my lord.
After discussing the who is talking?
I am saying the final order. This is not the final order.
Yes, my
This is
lord,
interim
this
order.
is final order. That was withdrawn, my lord.
That was withdrawn.
Yes.
Okay, that was withdrawn. So that goes.
That
So
no
there-
effect, my lord.
there was no effect.
Yes.
So I am affecting that clause 10. So I have challenged that.
I've heard you, Mr. Counsel. Let me hear others.
Yes.
You please sit down.
Now the point is whether he has locus standi to challenge this clause 10 at the middle of the year, my lord. That is the main issue, my lord. Yes, he participated and without challenging of clause 10, he was beneficiary because of the stay order of that writ petition for a moment. Now that will not accrue any right to him, my lord, to challenge clause 10 at this stage.
Correct, correct.
Yes, my, that is my submission.
Since my lord, clause 10 was stated by this honorable court, my lord. So my lord, I need not know to my lord challenge the clause 10. But subsequently, my lord, it has been withdrawn. Only one, my lord, 23rd, my lord, 1 to 2024, my lord. So I have filed this, my lord, immediately thereafter, my lord, I filed this petition. Challenge the clause 10. Because it was, my lord, earlier challenge.
Okay, only one question. Is page 86.
Yeah.
Page 86, please turn to page 86.
Yes, my lord.
Have you challenged this order?
Double thing, my lord, this petition has been,
Have you challenged this letter? Have you challenged?
it is in my favor. my lord.
No, no.
Yes, my lord.
Please read the last, please read the last paragraph.
However, the settlement shall be dependent on the final order of the honorable court in interpretation number 1. So, my lord, he has withdrawn this writ petition. Immediately thereafter, I have filed this my lord, writ petition, challenging the clause 10.
Okay, right. Dismissing your case. Otherwise, you go you go to the WA. You go
Yes,
to the,
appeal is pending.
you go there.
Yes, my lord.
You go there
So,
only.
so my submission to your lordship, my lord, the matter may be listed after 2 weeks after my lord, I did appeal.
No, no, sorry. Heard, Mr.
CA Kaiyum.
J. Kayub, learned counsel for the petitioner.
I'm for resolution number 1 to 5, madam.
Also heard, Mr.
As the term 1 for 1 to 5.
As the top for response number 1 to 5, and Mr.
A Sharma for respondent number 6. I'm one of the victims.
Anybody else?
No, madam.
Who is 7?
7 is also a private respondent, my lord.
Who is he?
One of the bidders. We don't have any.
Party also.
Okay. Right. The petitioner is aggrieved with clause 10, you said, no?
Yes,
Yes, madam.
Where is that page?
page my lord, page 25, then operative part at page 26. And I
Is aggrieved with clause 10 of the tender notice for 2023-24 year dated 29/4/2026, page 25, huh? Comma. Wherein it has been provided that the tender for all bazaar/ghat/Meen Mahal/pound offering the highest bid price will be considered for settlement. It further states that if the tenderer offering the highest bid price does not enclose the relevant papers and documents, bracket, except court fee and earnest money, bracket close, comma, he/she will be given a period of 3 days for submission of such papers and documents. And if he/she fails to submit the papers and documents within the specified period of 3 days, comma, his/her tender will be cancelled and his/her earnest money will remain forfeited. And the next highest bidder shall be considered for settlement within the set terms and conditions. Full stop. Next para. The petitioner took part in the selection process for settlement of the Bali Satra bi-weekly market. Bracket in short market, huh? Issued by the Bata Drava Anchalik Panchayat in pursuance to NIT dated 29/4/2023. The petitioner was the second highest.
I am the bidder, the fourth highest bidder,
The petitioner was the fourth highest bidder.
but it was considered as valid.
Fourth highest bidder. Full stop. What happened to number one?
Now, Lordship, after the withdrawal of that order, my lord, we will offer clause 10 effect, my lord. Thereafter, if he will accept it, then he will submit document. Otherwise, next 2-3 will come, my lord. If they will also not accept, then he
What?
will come.
My question is, why was he settled instead of 1, 2, and 3?
Because
Clause 10 was
the.
Because none of them had
One,
submitted
two,
that.
Yes,
papers
yes.
were deficient.
Yes, yes.
Okay, so all,
Yes.
They have replaced
so
it
how
with
many tenderers were there altogether?
Altogether, my lord, there were
38,
12%.
33 million.
33, yes.
Around 33.
30 that time for
Yes.
that market.
Yes, yes.
So 33, and out of 33, he was fourth.
Yes.
So the first three were not considered because they were deficient.
Yes.
The deficiency
Non-effect of clause 10.
on effect. First up. Next. What have I said? Amongst 33 bidders. Full stop. The petitioner was selected as the successful bidder for settlement of the market on account of
Sorry.
the three highest bidders not having the required documents in their quotations on account of clause 10 of the tender notice dated 29/4/2023. Who made a challenge? Where is the challenge made by whom?
Yes,
Next
ma'am.
para.
Bidder,
The challenge was made, my lord, by different bidder, my lord, which are different under the same Anchalik Panchayat,
But not for this market.
not for this matter, because the entire Anchalik Panchayats were togetherly notified, my lord.
I think it was for this market.
It has to be from this market, otherwise how can he make a challenge for some other market? How can it be? Where is that judgment? Where is that?
page 36.
Has to be for this.
Yes, my
For
lord.
this market.
Serial number 3, my lord.
For this market.
Mukhtar Hussain, serial number 3, my lord. Page 58.
58.
Yes, page 58 is the comparative
Why-
statement, my lord. This is the comparative statement.
Where is the judgment?
Page 36.
36 is different. 36 is where the stay order is.
Yes, madam.
Yes.
There was a case against settlement of the market
Yes, ma'am.
against him. So where is that case?
Page 88, madam. Page 88. Page 88.
Page?
88.
Mukhtar Hussain.
Yes,
Okay.
Dr. Hussain and Milot Raisuddin Ahmed, two petitioners. 6 and 7.
This Mukhtar Hussain, what is his serial number in the three? And this Riyaz Uddin?
5.
5. So they 5 also had given what 5, but you are 4.
Yes, madam. He has also challenged that Milot, my tender was defective.
Different. Okay. But Mukhtar Hussain has challenged on the ground that he's got a higher bidder.
Yes,
He's
madam.
the higher bidder.
Right.
Okay, right. Then the third highest bidder, Mukhtar Hussain, filed WPC 4757/2023 against the petitioner on the ground that the petitioner could not have been settled with the market as he had Now, as Mukhtar Hussain had submitted a higher bid for the market than the petitioner. One, Rais Uddin Ahmed, RAIS, Rais Uddin Ahmed, who was number 5 amongst the tenderers, made a challenge to a settlement of the market with the petitioner by WPC number 7469/2023 on the ground that the no on the ground that the petitioner's the tender documents did not fulfill the requirements of the tender conditions provided in the NIT dated so. Next. Acha, before this, you just write. Before filing of the case, you just write page 86. The no, before that, you just write that during the selection process for considering who was to be the successful tenderer, clause 10 of the NIT dated so had been stayed by this court by an order dated 9/6/2023, passed in WPC number 3325/2023, which was with regard to settlement of another market. Is it?
Yes.
Settlement of another market. And which is
Same market.
Balishapura market.
Acha.
Balishapura market.
Acha.
That NIT has got multiple of markets.
Ha.
One of the markets therein is Balishapura market,
Okay.
which is the present market.
So, but this is not with regard to him.
Yes, Balishatra with me.
3325 of 2023, you're not a party here.
No, I was the party respondent number 7.
In
In
332,
275 million.
where is that page?
There's 36 million. I was minority included, thereafter Miller.
You are implemented subsequently.
Yes, Miller.
Who has challenged this?
Some intending bidders.
One petitioner who was the intending bidder,
Aha.
he
Okay.
was against this particular clause 10.
Okay.
Before participating, he challenged it.
Okay, but
And there is a
he did
stay
not.
order.
But he did not take part.
Participate, Miller. Mukta
He
Hussain.
participated.
Participated, later on he withdrawn.
Okay. What have I said? No,
Masatra.
prior to the selection. you
Yes,
say.
prior.
Prior to the selection, what have I said? Now, had been stayed by this court. Passed in. Which was with regard to the same market. That is
Balishatra.
Balisatra bi-weekly market. As an intending tenderer. As the intending tenderer, Arshadud Zaman
Asadul Jamal.
And two others.
and two others. Page 36. Had made a challenge to clause 10 of the said NIT. Full stop. Then the next para, you write. The selection process for settlement of the market was made during the pendency of the stay order passed in WPC 3325/2023. And the said market was settled in favor of the petitioner for 12 months from 1/7/23 to 30/06/24 at an amount of rupees 1,52,00,000. 1 crore, that means 1 crore 52 lakhs.
1 crore 52 lakhs.
By letter dated 30/06/23 issued by the Chief Executive Officer, Nagaon Zilla Parishad. The said letter dated 30/06/2023 also carried a rider that the settlement would be dependent on the final order of this court in WPC 3325/2023. 3325/2023. Then you come to that. Whatever I said thereafter, the challenge was made. Ha. Correct. When did he withdraw the case? That 3325? When was it withdrawn?
Without any reason.
On 23.
Whatever it may be, I'm not,
On 23/1/2024.
23.
Yeah, I have given the order, my lord.
1/2024.
23/1/2024.
My lord, I have
Petition
given the
was
order, my
closed
lord.
on withdrawal.
I
Interim
was,
order
my lord,
issued, stands vacated.
Raised objection and it was recorded. And the petitioner was, my lord, given liberty to, my lord, to approach, my lord.
Where is that order?
I have just,
Just now.
yes.
Okay. Okay, next. Then carry on, huh?
Double three.
WPC number 4757/2023 and 7469/2023 were disposed of while order dated 11/1/2024.
The direction appears, my lord.
Just a minute, Mr. Counsel. Please sit down.
I am existing.
Please do not assist, only when I ask for assistance. Right. What have I said? While order dated so by holding that the court had noticed deficiency in the in documents of the bids of the petitioner Mukhtar Hussain as well as the private respondent, who is the petitioner herein. The court further held in the order dated 11/1/2024 that the difference in the price offered, which is rupees 18 lakhs, cannot be termed to be a minor difference, especially in matters of distribution of state largesse, which are meant primarily to fetch revenues for the state. The decision of this court in WPC 3314/2019, bracket Maleghar Gobindapur Fishery Cooperative Society Limited was State of Assam and others was also quoted, where it had been held that in matters of distribution of state largesse, which are meant for fetching revenue, the price offered is of paramount importance. The court thus directed the respondent authorities to redo the exercise of settlement by giving the petitioners and the private respondent to make good any deficiency in their documents within a period of 5 days from the date when the authorities would make a notification of the same. Full stop. The settlement order dated 23/6/2023 made in favor of the petitioner was accordingly set aside, and a direction was issued that a fresh settlement should be offered to the valid highest bidder in accordance with law. Full stop. Being aggrieved by the order dated 11/1/2024, passed in WPC 4757/2023 and 7469/2023, the petitioner has put the same to challenge before the division bench of this court by WA number
21 and 23. Because two open that may two distribution.
WA number? Just tell me.
21 of 24 and another WA
21 of 24 and WA
23 of 24.
23 of 24. Full stop. Next para. No, continue. The writ appeals are apparently still pending before the division bench as on date.
And status quo order was passed.
How does it matter whether status quo order was passed?
Because the authority is now running the market, and the authority has not completed the process.
Okay. Okay, right. But the status quo order is not in your favor.
Neither of the parties, my lord. It is now the.
Okay, status quo order was passed by the division bench, wherein the factum of the running of the market by the authorities has not been disturbed by the division bench of this court. Next para. Pursuant to the above facts, WPC 3325/2023 was withdrawn and the interim order passed therein was vacated. While order dated 23/1/2024. Next paragraph. Thus, in view of the above facts, in view of the above facts, the question is with regard to who should be settled with the market and whether the terms and conditions provided in the NIT dated 29/4/23 would hold the fee. Full stop. Next para. In view of WA so WA 2 having been filed by the petitioner, the question that has to be decided would be with regard to whether the division bench no, don't say that. What have I said? No, just before that. That review the above facts, comma. Uh, the the issue to be decided is whether clause 10 of the NIT dated 29/4/2023 can be put to challenge in the present date petition. Full stop. It is not denied by any of the parties that at the time of submission of their tender document, comma, the said clause 10 was did you know that it was when did you submit your tender?
After that, my lord,
When did you submit your tender? What date?
for 12, my lord, 12/6.
On 12/6. 12/6/23.
Yes, sir. And the interim order was passed on 9, my lord, 6.
Did you know that this interim
Yes.
order, huh?
Yes, my lord. Because my lord, the authority was given benefit to me. It was subsequently, it was circulated. That is, my lord, page 47, my lord.
Suppressing one more thing, my lord. There was a notice, my lord, that was notified that because of this case, clause 10 will be not affected.
Where is that?
That
Yes,
is there.
47, my lord.
Yes, he is aware of that, my lord.
What
Page
have I said?
47. Hmm? Oh, my lord. Where is it?
Another tender that notice dated 19/6/2023 was issued by the executive officer. Who is this? This point number was issued by the was issued by the respondent number 5
5, yes.
to the effect that clause 10 would not be made applicable. Clause 10 of the NIT would not be made applicable in view of the order dated 15/6/23 passed by this court in WPC number 3325/2023. Then
My lord, last line of that notice, my lord. Until the further order of the
or
honorable
until
body.
further order
Yes.
of the court, of the High Court. So full stop.
This was issued on 19/6, my lord, and he deposited on 12 itself.
On 12/6.
12 June.
Correct.
Yes, but he didn't challenge the clause 10 before participating in the bid mice. That is the main point.
After 19/6, there would have been a ground that he didn't challenge because it was not put to application thereafter. But his submission came prior to 19/6 on 12/6. So he very well knew that clause 10 was there. He didn't challenge to that. He participated.
And after 19/6 also,
You
my lord,
cannot take advantage of this suspension or this letter of temporary suspension.
and even if, my lord, 19/6/2023, it is clear, my lord, that this will be applicable only the outcome of the WBC 332/23, which was withdrawn.
What was it? So, next para. As can be seen. No, full stop. No, full stop. The petitioner has, however, not put to challenge clause 10. No, before that. The petitioner had not put to challenge clause 10 of the NIT at the time of submission of his tender. Or prior to the, where is that page 40?
47, my lord, is a notice.
Or prior to the notice dated 19/6/23 issued by the respondent number 5. Full stop. Maybe we send it to the DB.
Yes, that is my.
My lord, the subject matter is different, my lord. Here only he challenged clause 10. And as per the order I have given, my lord, read appeal to 395/2022. He don't have any locus standi to challenge that, my lord.
What have I said?
In fact, my lord, that DB matters are also infractions. My lord. The order of the division bench may be seen, my lord.
No, but that's a different thing.
He can pursue his writ appeals, my lord, on his own merit, my lord. But this case does not have any merit, my lord, because clause 10 now he can challenge. He can't challenge, my lord.
Right.
Lordship may kindly once again go through the judgment I have given, my lord. In that matter also, clause 10 was challenged by another person petitioner, and division bench said, my lord, the petitioner does not have any locus to challenge because before participating he didn't challenge.
We'll list it again. Then list this matter again. Day after tomorrow.
My lord.
Let me think.
My subject lordship, my lord. The division matter is fixed on like 8.
Today's
It's like 5.
5th.
So my lord, this matter.
No, 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 no. Why should it be after DB matter?
No, no, my
I'm
lord.
thinking, why should it not go before DB?
Yeah.
Why should it be after?
And Lordship, my lord, prior to the interim order, my lord, then another coordinate bench, my lord, held the close claim is illegal. That is, I have given the order, my lord, in WC number 6902.
6902, you have
Yes,
not
ma'am.
given.
The order was passed on 17/5/2020.
Where is that?
I have
Okay,
given.
6902. Where is that?
That, my lord, Lordship, may kindly turn to page, my lord, 16, paragraph 21, my lord.
Yes.
From the above, my lord, it is certain that if clause 10 of the NIT is made applicable, then the same would for the benefit of the bidders whose bids were invalid at the time of their submission, and the same would be to the release to those bidders whose bids were compliant to the terms and conditions of the tender notice at the time of their submission. The issue of the acceptance or rejection of the bids, the bid of the bidder is to be examined by not only from the points of view of both the tendering authority and such a bidder, but also from the point of view of all other participating bidders. The said situation is clearly opposed to the principle of equality enshrined in the Article 14 of the Constitution of India. The same would clearly be discriminatory in as much as it would result in an anomalous situation where unequal would be treated equally, giving them an unjust benefit over a bidder who is otherwise the highest valid bidder in terms of the provision of Assam Society Act 1994 and Rule 4710 of the 2002 rules, merely because they have quoted higher bid value. Such a decision cannot be emphasized in a competitive bidders process.
We'll take up the effort tomorrow. This is the matter the effort tomorrow. But you type that out. I will dispose it of the effort tomorrow. Either way, I think it cannot be done in such a hurried manner.
Yes.
You see, the thing is that and clause 10 was there, no doubt. But then clause 10 was stayed.
State.
This has also been put to notice to everyone by the authorities. So at the time of consideration, clause 10 was not there.
Yeah. So how
Well,
I
not
can
there.
It was not there.
Yes. Yes.
Now,
After-
supposing the division bench says that there's nothing wrong with the settlement.
That order was also maybe kept in the file, my lordship.
Para?
Lordship, these particular cases.
Para.
Entire.
I cannot read the entire
My
thing just
lord.
for a thing. Just show me. You don't give, I'll give you
In these
20 books.
cases, my lord, series of cases, the clause 10 was challenged, my lord.
Para,
Yes,
where
yes,
is the
yes.
operative
Yes,
portion,
yes.
Mr. Councillor?
My lord, my lord. Para, my lord, 24 to 29.
Settlement that was made with him was a settlement of a temporary nature, because the
Correct,
last
correct.
sentence was,
Correct.
this is subject to the outcome of the writ petition wherein the clause 10 is under stay. So therefore, a final adjudication vis-a-vis the settlement had not taken place at the point of time. Clause 10 was put to
Conditional.
conditional. Clause 10 was put to a dormant state, and therefore, that for the market to run on a temporary basis, a settlement was given, putting it as a conditional settlement. Subject to,
So if that be the case, now he's put to challenge that
Yes.
thing, rightly or wrongly.
so whether he today
At that
had to-
time, of course, he could not
he
have.
could not. My case is, yes, clause 10. is
Only
yet to be challenged.
only the problem is that he has submitted his tender after the stay order was issued.
Exactly, my lord. The writ appeal number.
no, so that is
2522
busy.
is the same, my lord.
What's represented?
You're not understanding.
But my case would be, does he have the knowledge at that point of time?
That is the thing.
Because the notice.
That
came
that is
after.
the thing.
Yes.
Now he's going to say he has knowledge.
Has he
Naturally,
ever to that?
I don't
is
know.
there any ever to that?
You tell me,
I
has
think
he ever
his-
to that?
his no. His
He has
count
not
is-
ever.
His case is,
Because my lord, in view of the
notice
interim
came on
order,
19/6, his submission was 12/6. So on that day, he didn't knew about the stay order.
I don't know whether there is in his affidavit it is there
I
that he
have
knew
checked
about
that.
it.
That environment is not there, regarding the knowledge is not there.
Knowledge.
I
That is
understand.
what was troubling me. That's why I want to
I
read.
understand that. Had the stay order been there, he could have said, there is already a stay, there is no call of action for me to challenge clause 10 now. I participated. Now the case is withdrawn. Therefore, my call of action has arised and I have come back to this court. I understand that, but then
But then he took part.
Paragraph two is the
He took part.
statement, my lord. Paragraph two is his statement.
Yes.
Yes, my lord. And the last part, my lord, and page 5, it is stated that last date for submission of tender was fixed on 12/6/2023. Last date was 12/6, my lord, till
So?
2 p.m. It is mentioned that.
So what I
that
said,
was notice was issued later on, my lord, 19.
that is not the issue, Mr.
It was not
Counsel.
mistake.
Well, it doesn't mean
There
that
is no averment
that
that
is
he
what.
was aware of that, man.
the Asadur Command stay order that came prior to this, but
Anyway, we'll have to see. Let us
Well,
see.
yeah,
We cannot do it such a hurried
My
matter.
lord.
and division bench matter is different. Division bench matter is his settlement was challenged. That settlement. was
Correct,
challenged.
settlement.
That was set
So
aside.
that is a different issue.
Conflict is otherwise not there.
Anyway, how does
That
it,
matter became infructuous also, my lord, because that order was already
That I know.
withdrawn, my lord.
which other?
The say order was withdrawn.
Sure.
Now we are going to resettle with the clause 10. So that matters was infractions, my lord.
Anyway, so the
Yes.
thing is that it's very easy to argue. The only problem is
My
for
lord,
us, we have got to be careful while putting it down.
my lord, my lord.
Because we all are going to use it.
Checkered fact.
My
Yeah.
lord.
Earlier episode was
Next.
to the third minute.
Oblige the Lord.
I'll oblige.
Yes,
Same case.
same matter.
Same.
Acha, it'll be same as serial number 7. Okay. Same thing. Except out here the item will be, the amount will be 35,08,637.
So Lordship,
Huh?
item amount is Lordship 34,26,000 in page number 15.
Page number?
15 Lordship.
Then how do you reconcile this with page 28? Yes, madam. How do you reconcile it with page 28? This is your bill. After verification, they've given you bonus of 1 lakh. So be happy. Page 13 is your bill. Page 28 is their liability statement. So it is 35,08, A637. Okay.
Oblige Lordship.
Safe. Next.
There is no counsel for the
No,
respondent.
you tell me your case.
My case is this, my lord. I am a company. The director, because of mismanagement, went to the company law tribunal.
The director is your wife.
My lord, the director's wife, and ultimately status quo ante was passed.
No, let us see the impugned order.
The impugned order says, when I asked for that, the fixed deposits lying in the name of the big cylinder, they said that we are not being able to adjust that amount.
Is this a writ petition? Is this where's the writ lie?
My lord,
What possible right of yours has been violated?
because my amount, fixed deposits in the name of Vivek Cylinder is with the Industrial Cooperative Bank,
So?
47 lakh.
So?
And they refused to give it to me. They said, no, there is no fixed deposit.
So that is a question of fact.
Well,
You go to a civil court.
my lord, civil court in the bank, my lord, your lordship, their documents, your lordship will find at page 63.
No, you come to the main impugned order.
The impugned order is the last page, my lord.
Let us see what does it say.
With reference to be captioned above, adjustment of fixed deposit number such and such in loan amount number such and such. That was the adjustment. And with reference to the caption subject, please refer to our earlier letter dated. We have mentioned that without proper information relating to the caption fixed deposit, name of the depositor, date of issue and respective fixed deposit account number, it is not possible for us to find out the fixed deposit.
Yes, so
And
give them the number.
Page 63 is there, they have furnished me this document.
Where is how
My
does the
only
repetition
prayer,
lies?
let them come and file a affidavit saying that they have denied it. Because my fixed deposit is lying.
Mr. Council, please reply to their letter of 5/10/23.
5/10/23. Yes, my lord.
Where is your reply to this letter?
My lord, this was in reply to my letter.
Huh?
This was in reply to my
Now,
letter.
where is your letter?
My lord, earlier letter, that is the earlier.
This is not a writ, this is not a case for writ court.
My lord, then my lord, your lordship may give me that time up to 12, my lord, I will satisfy you.
No.
My lord,
No,
your lordship may just give me up to 12.
No. For 12 for what?
My lord, 12, I will satisfy that. my lord,
No,
that
you
document.
satisfy me now. There's no
But
question.
page 63, your lordship will find, they have stated this document, that subject 26 lakhs is lying with them.
Then that's a different issue.
My lord, that is there, my lord, page
I don't know.
Page 63. Page 63 and my lord, then my lord, page,
No, this is nothing to do.
and now the my lord, page 60, 71, 63 and 71.
This page 63 is our document of 2015.
My lord, this is the document they have furnished to me,
Mr. Council, where is now this page 81?
my lord.
Where is this comes from where? How did this document come out?
Because of my
You
information,
make a reply to this.
my lord, I will furnish it, I will furnish it.
No case.
My lord,
You
your
can
lordship,
go in appeal. You file a reply to this.
my lord, because my lord, this is in reply to my letter, my lord.
Which letter?
Well,
Of
earlier
2015.
Earlier page 78. Page 70 is my letter. From Vivek Cylinder to the Branchman Industrial Cooperative Bank to adjust my. Against that, they have stated, my lord.
Then you write another letter to them. Why should we go into your issue?
Well, only
What the part 3 right of has the violation?
my two fixed deposits are lying with the bank.
So
26 lakhs and 21 lakhs
26 lakhs
and
and
21 lakhs.
21 lakhs are lying with the bank. Then
Bank, my lord.
who's 26 lakhs? The
This
company.
is Vivek Cylinders.
Huh?
Vivek
Yes.
Cylinder.
So
So Vivek Cylinder is the company that I am the director now.
and your wife is
the-
also the director.
My lord, your lordship may look into page 44, paragraph 122. Page 44, paragraph 122. In the national law, I was the petitioner before the company law tribunal. National page 122.
Page 122.
Page 44, paragraph 122.
Page 44.
Paragraph 122.
Paragraph
122.
Yes.
This is a judgment.
Yes.
In our instant case, the petitioner has clearly made out a case of operation and mismanagement, as well as we have been continuing.
Against who? Against your wife.
Against my wife, she was the director, and the proceeding in hand, and therefore such action and conduct are declared null and void. The company is restored to be position ante 19/8/2009. So this was my and I got everything of the company, my lord. Now the fixed deposit is lying in the name of the company.
You
I
are
am
not.
asking for only a notice, my lord. If they come and say there
Sorry.
is no fixed deposit, my lord, in a civil suit, my lord, we cannot go for declaration, my lord.
You file a writ. You file a petition to them.
My lord, with that observation, your lordship will give it, that they will, at least that observation may be given, my lord. Because the status quo ante was there from 2009. I became the director. Because there is a loan amount of 1 crore. I have paid 39 lakhs.
Is there any alternative remedy available?
No other alternative remedy available, my lord. Civil court, I cannot go, my lord. They have refused to give it. This is under, my lord, this is a state under Article 12, my lord.
No. This is regarding you and your company.
Company and the bank, my lord. Company and bank, my lord. Vivek Cylinder. This is petitioner is Vivek Cylinder. Company is a separate legal entity, my lord. This company has come before the court, my lord. NCLT has status quo ante of 2009, my lord. I got the judgment in 2018, my lord. Your lordship will find the judgment was passed in 2018. At page, my lord, 19, your lordship will find.
Page number?
19, the judgment starts, my lord. And the bank was a party to that, page 20, your lordship will find. Bank was party to the NCLT. So respondent number 8, and they didn't.
First of all, the documents are not complete also. The judgment also not complete.
Judgment is from page 19.
Judgment dated?
This is my lord judgment of 2000, dated 7/4/2017. It is there in page
7/4/2017.
17. It is just after the name of the page 19. 7/4/2017.
7/4/2017 passed in.
My lord, NCLT case TP 21 of 390 under those sections in CP 188 of 2015.
Now what does it say?
There's paragraph 22, status quo ante. I got it from back from because misappropriation, everything was taken over by that the lady, and then what I got this misappropriation under this section of company law.
Page, where is where does it end? Where is the?
It ends at page 45.
Page 45.
My lord.
Yes.
My lord, accordingly, the company is directed to repay the amount of to the respondent number 2 and 4 the compound interest such as calculated quarterly from the date of such amount and repayment of interest due to respondent number 2. The transaction shall be completed in 2 months from the date of receipt of the certificate copy of the report.
Then?
And my lord, the main portion is at para 122. It was status quo ante.
No, then.
Page 44, it was past status quo ante. And I was directed to pay the 1 crore loan. I have paid 39 lakhs. Now this 47 lakhs is lying with the bank.
Now, what is this page 46? Is it a part again? It's what is this? The same case.
Same case, my lord. There was ultimately a compromise, and ultimately I have to pay that 1 crore. 1 crore loan that was there, OD loan that I.
So this case ended in a compromise.
Compromise. I have
now. So what has happened? So this case is finished.
Finished, and I paid. My lord, I paid 39 lakhs of the 1 crore OD. And my lord, that was my query before the bank.
Just a minute. So
overdraft of 1952. That page 78, your lordship will find. I made a
page 59. So what is wrong now? Now this is finished. Now what remains?
Now the question is this, my lord. I have asked that OD is there. The OD I was paying 30. I paid 39 lakhs. The balance 47.
Where is that letter? The OD regarding what? Where have you stated? What is this?
Page 78. This was the query I made to the bank, and the bank in reply has said that one. That is why I am before your lordship.
No, there's nothing. You go.
But only thing your lordship may, otherwise, if your lordship wants to dismiss.
Yes, I'm dismissing it.
Not only thing, my lord, your lordship may allow me that I will satisfy your lordship on that count. Let it come out.
No, nothing.
Or your lordship may already issue notice, my lord.
No. There's nothing here. You file a reply to
Because
this.
if this is if that be so, my lord, where is the alternative remedy, my lord? Where I have to go?
You file you go to the civil court.
Well, civil court cannot decide, my lord, that whether fixed deposit is there or not.
You see, when the bank itself has asked you name of depositor, please give name of the
already. Name of depositor is in the name of Vivek Cylinder. So why should I give it again and again? The name of
where have you given it name and again?
Yeah, the letter was from Vivek Cylinder, page 78. Page 78. The letter was from.
What does it say?
Now they reply to Vivek Cylinder.
No. Where does it say fixed deposit? Name of the depositor. Where does it say?
That is the letter at page 63. Is Vivek Cylinder. Page 63 is a Vivek Cylinder. Vivek Cylinder Private Limited. In the name of this is the fixed deposit is lying with the bank. This is 26 lakhs and another one is at page 71.
Where?
That is there, my lord.
Security held.
Security. This is fixed deposit.
No.
And my lord, at page 71, FDR, security held 21 lakh 62,000 in FDR. Page 71.
Okay, list this matter day after tomorrow.
Not day after tomorrow, I will be, let it be on 12th, my lord, or 14th. 12th or 14th? So 12th, my lord.
Why not this week?
My lord, I'll be out, my lord.
Okay, let me see. Let me see. I'll pass an order today. Let me see. Either way, it might be dismissed, might not be dismissed.
My lord, if your lordship is going to dismiss, I have no other alternative.
I'll see. Agenda.
Okay.
Maybe lost, my lord. Here, my lord, we are the petitioners, my lord. Against this setting up of a mobile tower, my lord, just on the vicinity, just 2 meters from my house, from our house. I have also annexed the photographs, my lord.
No, that's all right. All right.
Yes.
Photographs are there.
Yes.
Now, what do you want?
I want, my lord, that because under the guidelines of 2023 issued, my lord, I have annexed the guidelines, my lord, you will also kindly come to page 17.
Yes.
They must ensure, my lord, safety, my lord, just a minute. Page 2021 is the relevant page, my lord. 1920. This is under rule 1, my lord, rule 5 of the guidelines, my lord, clause 5. You also kindly come to next page, page 20. Sub clause 7. The self-declaration license C in respect of mobile tower based transceiver system that all general public areas around the tower shall be within safe electromagnetic radiation exposure limit. Antenna starts radiating. And 8, clause 8, in case the mobile tower is to be installed over private property, it is private property, my lord. The licensee shall intimate the nodal officer in writing along with details of building or structure where the mobile tower is proposed to be established and a copy of structure safety certificate certified by an authorized structure engineer before commencement of the such work. This is not looked into
What
because
do you mean not looked into?
my lord,
You see, these things, this will be looked into by the nodal officer.
nodal we have complained, nodal officer to my lord, deputy commissioner, he is
So-
the chairman also.
Ah.
We already put objection when you came to my lord that there is a plan for setting up tower, mobile tower, high power tower, about 120 meters tall on the just vicinity of our land.
So then let the nodal officer take a call. Let him take a decision.
He has not, I have, that annex, I have annexer 5/61, madam. We along with the other public, members of public, madam, put an application before him on 8/6/2023 itself. Till date, no response and SMS is particular version is on page 62, signed by here about 49 people.
But you are challenging it on what ground? The
On
direction of a tower.
Safety matter.
Safety.
Because there will be radiation, there is no doubt. Because that's what the guidance says. Radiation has to be matter within the limit so that we do not have public safety is there. So, our do one thing, my humble prayer is that let the nodal officer, the deputy commissioner dispose of with reason our application pending before him since June 2023 and with reasoned order.
Okay, page 61 should be disposed of, that's all.
This was the matter to the nodal, directly nodal officer to give reason matter in the order.
As he'll reply to your issues raised, right? Heard, Mr. R.P. Sharma, the senior counsel, appearing for the petitioners.
Yes.
And assisted by Mr.
M. Rahman.
M. Raman. Next para, heard Mr.
G. Bokolia.
G. Pokolia, appearing for
1 to 6.
1 to 6.
One.
Anybody else?
No one. They are private students also. That,
Next, right.
The
The petitioners are aggrieved by the
annexer, my lord.
by the letter dated 29/12/2023
And my lord, 26/8/2023.
issued by the wait, there is, where is this 29/12/2023 page?
That is by the SP letter directly to the OC to give protection.
Okay, right. The petitioners are aggrieved by the letter of the District Commissioner Sonitpur dated 21/12/2023 and letter dated 29/12/2023 issued by the SP Sonitpur to the OC Tezpur Police Station.
Yes.
Informing them to, where is that page? Where is that letter?
Page 61, my lord.
No, page 61 is your document.
Yes.
Where is the SP letter?
SP letter annexer 1. Page 16. There he has quoted this is order, my lord.
Directing them to take action as per law. So, sir, the grievance of the petitioner is that
Then what is that? Safety norms against radiation.
is that a mobile tower is going to be constructed on the private land of the respondent number 8, which is within close proximity to the residences of the petitioners. So, sir, the petitioners being apprehensive of their safety in view of the electromagnetic radiation
Exposure.
that would be given out by the mobile tower had submitted a representation to the nodal officer
From deputy commissioner.
in terms of the guidelines for granting right of way to telecommunication infrastructure in Assam, 2023. Who is the deputy commissioner? Who is the deputy / district commissioner of the district? However, the deputy / district commissioner Sonitpur has till date not taken a decision on the petitioner's representation dated 8/6/2023. Bracket page 61 of the writ petition. The counsel for the petitioner submits that the writ petition can be closed if a direction is issued to the deputy / district commissioner Sonitpur to examine the petitioner's representation and take a decision on the same within a period of Within a specified time period. Mr. So-and-so, learned counsel for the respondent submits that he has got no objection to the prayer made by the petitioner's counsel. Pusta. In view of the consent of the parties, this writ petition is closed with a direction to the Deputy/District Commissioner Sonitpur to take a decision to examine the petitioner's representation dated 8/6/2023, bracket page 61 of the writ petition, that close, and take a decision on the same within a period of 1 month. 1 month from the date of receipt of a copy of this order. The writ petition is accordingly disposed of.
In the meantime, my lord, the private respondent shall not commence the work.
No.
Otherwise, it will be infectious, my lord.
Electronic, there is no proof regarding this. This issue is there all over the world, you know that.
Yes, but it is just 2 meters.
No. Cannot.
Oblige, my lord.
Item 13 and 14, both are analogous matters, my lord. Both pertain to non-payment of contractual duties. The lordship would take up 13. And I'll very briefly narrate the facts, my lord. My lord, here, Amulya Prasad Desai. Bring this. My lord, the PWD Karbi Analog, my lord, by way of a letter of acceptance, issued a work to the petitioner company, my lord. The petitioner before your lordship is a company, my lord, incorporated under the Companies Act. My lord, will directly come to page 19 for a moment, my lord. 19 of the writ petition.
19 of?
The writ petition, my lord. Lordship is taking up item 13, Karbi Projects, my lord. Messrs. Karbi Projects Private Limited. Page 19.
Yes.
This is the letter of acceptance. Subject improvement of BBDC road from 19700 to CH 2070. So, my lord, the last paragraph, if you are agreeable, you are hereby requested to sign the tender agreement within 3 days and proceed with the work in consultation with the executive engineer PWD Borpathar so-and-so. So, this work was finally.
Okay, basically, so you have completed the work.
Completed. The work
You have completed the work and you have not been paid your bills. That's your case.
Not paid my bill, my lord.
Ah.
The work completion, my lord, will find at page number 22. The work completion.
Now, what is the stand of the respondent?
Yes,
Let us
the
go through it.
stand of the respondents, my lord. Strangely, my lord, there are 3 affidavits, my lord, filed by the respondents. The first affidavit, they take 3 grounds, my lord. They don't deny the fact that the work has been executed. And in fact, I have made a categorical statement in the writ petition in paragraph 12 that the last payment was.
No, let us be very clear.
Yes.
Let us be, you see, do not go into nitty-gritty.
Yes.
Basically, because this is regarding payment of bills.
Yes.
So we shouldn't go into the nitty-gritty.
Right.
The first thing we have got to see is whether there is admission or not.
Yes.
It appears there is no admission
Yes.
for the simple reason that they are saying that you have not completed the contract work. You started it, but you did not complete it accordingly. And since the fund lapse, they had got the work completed by some other agency, contractor, correct? According to them? No,
Not exactly, my lord.
Not
Little bit
exactly.
Here and there.
Okay.
I'll tell.
but they have not admitted
They have
that
admitted,
they have not admitted that you should be given the said amount.
they have admitted that I have completed the work, but they
Huh.
don't want to pay up the money, my lord. That's the. I'll come to the affidavit, my lord. In the first affidavit, there were 3 grounds which were taken, my lord. The first, they say that the project for taking out, my lords, we look into the 1511 order.
That's what I'm looking at it.
Yeah.
That's what I've seen.
Yes.
That has been reflected in this order. That's
Yes,
what.
Yes. So, my lord, they take 3 grounds, my lord. The first, that the project has been foreclosed. Now, when they say the project has been foreclosed, it's not that my work was not completed. My work was completed. Work completion was issued in 2014. There were payments made during this period, and last payment was made on 5/2/2020, which they don't deny in their affidavit. They've already paid. They owe me an amount of 14,91,000 for the work, for the total amount of 56,55,000. So amount has been paid. They don't deny the fact. Now they take three grounds. My lord. They say the first, that the project has been foreclosed. Yes, project has been foreclosed, but it's not because of my non-completion of the work. I completed the work. It was under a project. At last, it was given to some other contractor, some other work, not
We
my work.
cannot go into
Yes,
disputes,
exactly. It has to appear from the affidavit. So my lord would come directly to the first affidavit, my lord. And they say, first affidavit,
Wherever I find disputes, then it goes. Your petition goes for a 6, just remember that.
right, my lord. So for that, my lord, I've got a judgment, my lord. The latest 2023, which operates in this field, my lord. The Honorable Supreme Court has held, my lord, that this denial, it cannot be a mere ruse or a pretense. There has to be something from, if from the documents I can show that the money is owed to me, as respondents, they
But
cannot attack their own order.
can that be decided in a writ?
Yes.
Writ.
Yes, I'll cite the judgment, my lord. My lord would come to paragraph 5, my lord.
Affidavit dated?
Affidavit dated. My lord, this is received on 30/11/2022. It's dated
Yes, 30/11/22.
30/11 on the same.
Para?
Paragraph 5, page 29, my lord, the running page. May I read, my lord?
Yes.
The deponent begs to state that the petitioner was allotted the works under so and so, which was a central sponsored project. The work was under a definite scheme for the year so and so. The total cost of the project was so and so lakhs, out of which central share was so and so, and the share of the state was so and so. The amount released by the government of India towards the project was so and so, and the state of Assam are rupees 401 so and so. The total works allotted to 53 groups, dividing works to all different groups to execute the work within a stipulated period. The petitioner, Messrs. Karbi Project Private Limited, was allotted 3 groups of work, and the other 50 groups were allotted to other contractors. For the works executed by the petitioner, an amount of so and so was paid, and the amount paid to 50 other groups were such and such. Thus, total release amount. My lord, take note of the affidavit, my lord. Thus, total release amount of so and so has been paid to different contractors. The total fund received from the government are so and so of the total project cost, and my lord, take note, my lord. Messrs. Karbi Project Private Limited has been paid 89.79% of the amount against the work executed by them. Now, what is this? It's a clear admission. So, my lord, I'll come to the next paragraph, my lord. Lordship would again come to paragraph 10, my lord, 32.
Yes.
That the deponent begs to state that until and unless the government releases the fund for the
Central government.
central government releases the fund for the project, and the deponent is not in a position to make payment. So they say they don't deny the fact that the work has been completed. Now, my lord, one thing, my lord, this is required to be pointed out. Lordship, may kindly take up my writ petition for a moment, my lord. Page 12. Page 12 of the writ petition.
So you have not made central government a party?
Yes, because I'm not privy to contract with the central government. It was issued by the PWD. Everything, money was paid. I applied before the PWD. The scheme, the original scheme is funded by the central government. That is it, my lord. There's no privity of contract of the petitioner with the central government. It's with the PWD, and this is a settled law, my lord. Lordship would come to page 12 for a moment, my lord. My lord, before the annexure, my lord, last 3 lines. The last payment of the outstanding bill, Lordship has it, my lord. The last payment of the outstanding bill was made on 5/2/2020 for an amount of 10 lakhs. Now, my lords, part payment would not have been made if the work was not completed. And now, my lord, this specific government, they have not replied to it, neither denied, they have not denied that payment was made. Now, my lord would come to their second affidavit. Now, they change their stand. This is the first affidavit. First affidavit, they say no funds, central government have not made a party, and they say that 89% of the total amount was paid, my lord. Now, my lord would come to the second affidavit, my lord. I'm so sorry, my lord. My lord, would come to my lord, the second affidavit, which is dated 31/7/23. Page 42, my lord, the third paragraph. The work of construction, lordship has it the last line.
Additional affidavit.
Additional affidavit. my lord. Filed by the respondent number 6, 31/3. May I?
Yeah.
Yes, madam. Page 42, internal page, the third paragraph. The last line starts from the last line.
Page 42.
It's marked page number 2, madam.
Page 2.
Page 2. But serial numbering is 42. madam.
Additional affidavit on behalf of respondent number 6.
Respondent number 6. The third paragraph, last line.
Third paragraph, last line, yes.
The work of construction.
Yeah.
The work of construction
Page
of
58.
BBDC road CH so and so, this is the work for which we're claiming the amount, was issued by work order dated so and so, but the petitioner did not complete the work for construction of the road from so and so within the stipulated time. Now, they're not saying that the work was not completed. They are saying that it was not completed within the stipulated time, and I agree, my lord. But that is not the, at this stage, that cannot be questioned. It was not completed. I was given an extension, and during the extended period, I completed the work, and there's a valid work completion certificate issued by them, my lord. They do not challenge that. They cannot challenge that.
Okay, next.
My lord. Then again, a false statement has been made. I should point it out to the court, my lord. Paragraph 5, that the petitioner segregated his claims to construction of BBDC road under NLCPR project for 2008-9 was a single project. The works of construction of road, my lord, would take note, my lord, kindly. What does it say, my lord? It's a different work they are referring to. The works of construction of road from CH 900 to CH 1450. My work is 19,700 to 2,700. 9,000 to 14,500 could not be completed by the petitioner in time. For the failure to complete the work, the notices issued to the petitioner. The notice dated so and so reveals that the petitioner completed only 30% of the works. So this is not even relevant. They're referring to a different work. I'm not claiming money for this work, my lord. I don't know for what reason, my lord. How is it important here? But they have quoted this, my lord. Now, my lord, will come to the third affidavit, my lord. Again, one more affidavit this time, my lord. Here, my lord.
Yes.
To cut it short, my lord, I'll just give the paragraph numbers. Paragraph 6 and paragraph 8. The two objections. Now they come up with the objection that saying that my limitation has expired to claim that money because 13 years have passed from the issuance of the work order. I'll reply to that. Now they take this stand of limitation. And one more stand, they refer to a judgment 2021-10 SCC 690, Pune Hinda, where they try to say that if there is a dispute, you are not entitled, the court is not entitled to give relief. That is the 20 position what they try to point out, my lord. Now, my lord, with regard to the limitation of 13 years, my reply to that would be that the work completion was issued in the year 24/9/2014. On 5/2/2020, admittedly, payment was made, which I have averred in my writ petition, which has not been denied. If last payment was made on 2020, my lord, first of all, limitation as per Tamsher Ali clearly spells out that in cases of non-payment of contractual dues,
yes,
limitation won't apply because it's a writ proceeding. But nonetheless, I would like to satisfy your lordship on the point of limitation, my lord. Limitation, last payment was made.
Okay, leaving that aside. Then
Yes.
next, what is the next point?
Yes, I'm just section 18 of the Limitation Act, acknowledgement. If you acknowledge that
But
money is due.
you have to acknowledge within the time. You cannot acknowledge subsequent after that.
No, because payments were made in between. If there's an acknowledgement, my lord would see this, my lord, once. I'll just.
And
show
next.
you. Yes. my lord, move up. Third document. My lord, this is a statement. What is owed by the PWD. My lord would first come to the date on the last page. This is 24/2023. Now my lord would come directly to my project, my lord. Serial number 42. Serial number 42, my lord.
Yes.
So and so, the name of the petitioner, my lord, Messrs. Carby Project Limited, 16 so and so, and work completed, and the amount which is due is 14,75,040. And my lords, this is not a statement only with regard to the petitioner, other contractors as well, who, to whom money is owed by the department. And this is 2023. Now they are admitting themselves, my lord, that money is owed to me and I should get the payment. My lord, one more, my lord, I'll just point out, my lord, I'll just place two paragraphs of a judgment, my lord, if required, because he's referring to Puna Hinda, my lord. He'll refer to that.
Please give me, you're wasting time. Go on the periphery.
I'll read it out, my lord. Now, this is reported in (2023) to SCC 703 MP Power Management versus Sky Power, my lord, Division Bench. I'm referring to paragraph, my lords, 82.1, 82.2, 82.3, and 82.6, my lord. 82.1, it is undoubtedly true that the writ jurisdiction is a public law remedy, a matter which lies entirely within a private realm of affairs of the public body, may not lend itself for being dealt with under the writ jurisdiction of the court. The principle laid down in Bareilly Development Authority that in case of non-statutory contract, the rights are governed only by the terms of the contract and the decisions, which are purported to be followed, including Radhakrishna Agarwal, may not continue to hold good in light of what has been laid down in ABL and as followed by the recent judgment in Sudhir Kumar Singh. The mere fact that the relief is sought under a contract which is not statutory will not entitle the respondent state in a case by itself to ward off scrutiny of its action or inaction under the contract. If the complaining party is able to establish that inaction is per se arbitrary. 82.6, my lord, the last paragraph I'm referring to, my lord. Without intending to be exhaustive, it may include the relief seeking payment of amounts due to aggrieved party from the state. The state can indeed be called upon to honor its obligations of making payment unless it be that there is a serious and genuine dispute raised relating to the liability of the state to make the payment. Such dispute ordinarily would include contention that the aggrieved party has not fulfilled its obligation, and the court finds that such a contention of the state is not a mere ruse or a pretense. Such denial cannot be a mere ruse or pretense. I have pointed out from the documents, my lord, that they have admitted themselves that that money is owed to the petitioner, my lord. In fact, as late as 2023, my lord, they have admitted, my lord, that there is that document. And my lord, in this regard, my lord,
that's all.
Yes, and just a one line I'll place, just one line. My lord, the Supreme Court judgment which says, my lord, the respondent in a writ petition cannot be allowed to attack its own order as a respondent. Now, they have not said why the work completion was passed, why so many documents. And the fact that payments were made, my lord, 2020 payment has been made. for the same work. The fact that payments, the part payments were made would itself show, my lord, there was successful completion of the work.
What you been looking to annexer 1 page 35 of the our affidavit, my lord. That is the scheme of the, my lord, central government, my lord. Our annexer 1 page 35. That is the route from 1 to 31 kilometer in Assam. That is a single project, my lord. So, and the main page 37 clause is the time frame for completion of the project is 24 months. The date of this sanction letter would be reckoned as the date of the start of the project. Target date of completion of the project would be June 2011. Time frame is to be followed strictly. Next, my lord, clause J. The project shall be implemented strictly in time and with the help of so and so, so and so. Next, my lord, clause M. If the project is unduly delayed without sufficient and valid reasons, it would remain open to Ministry of Donor.
Mr. Counsel, your basic case is that the work has now been completed by some other contractor.
My lord,
Who
subsequently.
is that?
My lord, that they have annexed it. We have annexed it, my lord. My lord, that is the order, my lord. That is the page annexure, my lord. 4 page 40.
40.
Page 40. Same road, my lord. That as they could not complete the work, the chief engineer PWD, my lord, they have, my lord, engaged another contractor and completed the work, my lord, after foreclosure of the work, my lord.
So this MP
MP
Agarwala,
Agarwala, my lord.
he's-
He
he-
had
he's-
subsequently, he had completed the work and it was issued by the chief engineer PWD, my lord. That is my lord, first point, my lord. And the second point, my lord, regarding alternative remedy, my lord, in this particular case, petitioner has not disclosed that there is a clause of arbitration. When there is a clause of arbitration specific in the terms, my lord, contract agreement, this is the agreement, my lord, there is a clause, my lord. That is a clause, my lord, first 25.3. I can hand it to the.
what is the, okay, let us see the contract agreement
This
is
is my
for
lord,
which?
contract agreement, my
No,
lord.
contract agreement is for this, what is the stretch of road from which kilometer to which kilometer?
My lord. There is a first page, my lord, March 2010, my lord.
From 9,000
My
to
lord,
14450.
my lord,
Now, if that be the case,
my lord,
let us see your page 40 to MP Agarwala.
my lord.
This you have given him from 00
To 31
to 31.
whole road, my lord, 1 to 31 kilometer. That is a, my lord, page 37, my lord, or page 34,
Page 39
page
would clarify.
35, my lord, page 35. BBTC road, improvement of BBTC road from 1 to 31 kilometer in Assam. Subject, my lord. Page 34, 35. There is a central government informed the additional chief secretary planning and development department, my lord. Administrative and financial approval for central financial assistance under non-lapsable central pool resources NLC peer towards project improvement of BBTC road from 1 to 31 kilometer in Assam. Whole road, that is one project, my lord. But when the work was divided into different groups. In the first case, my lord, he has given the three groups. In other case, my lord, second case, my lord, that work he has not completed. The petitioner did not complete.
Where
the
is
work.
the groups that he has been given the
My
work?
lord, so we have already annexed in our affidavit, we have stated what are the groups we have allotted,
Let us go back to that
my lord.
page 29.
In the additional affidavit, we have specifically stated, my lord. Page 42, paragraph 3. Additional affidavit filed on 31/7/2023. Paragraph 3. In this particular, there are three groups. What are these three groups, my lord? if a non-completion of the project in time, my lord, central
Page
government
40?
42, my lord. Internal page 2 of the additional affidavit, 31/07/2023.
There's not 42, 57 for me.
No, that is a third affidavit, 41.
No, no, no. All the judgments, they have been made, they have been paginated.
Oh,
So your
that-
42 is the
that's my lord.
Supreme Court
Oh,
judgment.
Lordship may look into my lord,
57, I've got it. 58.
that the work of improvement of BBDC road from so and so one a single project, well, that is a paragraph 3.
Okay.
I refer to that, my lord, last line, same time.
These are the 3 works, my lord.
Okay, so he completed 2 works, but he did not complete one work.
Construction work, he did not complete, my lord. That is a construction of the road, my lord. He's
That from
considerable
19,700
my
to 20.
in time.
So he's claiming for this third construction
My lord,
work,
my
only
lord.
for this.
Only for this one.
Okay.
But as he could not complete the work in time, as per the my lord sanction, central government did not release the amount. So how we can make the payment? If we receive the payment from the central government, then he should challenge that order by filing the reply. He has
Yes.
not stated anything on
Okay.
that. My lord, that is.
Yes. So you have not completed the third
No,
one.
my lord, things are
And
not,
regarding
not
the
how it
arbitration.
has been placed. After he submits.
No, no, you tell me.
My lord would come to page 39, my lord, of the affidavit, this first affidavit filed by them. Page 39,
Yes.
which is the precursor to the foreclosure of the work, my lord.
Huh?
This is for information of all concerned that subsequent to the termination of the incomplete work, Lord should take note, subsequent to the termination of the incomplete work groups of the project, improvement of so and so, so and so, so and so, which was sanctioned by the government, is hereby declared as foreclosed. Now, if my lord reads the notice, it says because, my lord, I'll explain, my lord. It was a scheme for construction of about 32 kilometers of roadways and other ancillary. So there were a number of contractors. In their affidavit, they have stated, my lord, there were 53 groups, and out of 53 groups, my lord, 3 groups were allotted to me, Sarvi projects. I'm here now because 2 groups completed, amount has been paid. I'm here for the 3rd group. Now, foreclosure, what does it say, my lord? It says this is for information of all concerned that subsequent to termination of incomplete work groups in the project. So first of all, the foreclosure happened because some groups works were not completed. My group for which I'm claiming is not included in that.
How do you know? How do you say that?
My lord, come to the affidavit, the same affidavit paragraph, my lord. Lordship, they have paid money for that, already been paid.
They have paid part of it,
Yes,
doesn't
yes,
mean
yes,
that
my
they're
lord,
not.
come to the affidavit, come to the affidavit, same affidavit, paragraph 5.
Yeah.
Paragraph 5, my lord, page 4.
Yeah.
I'll read from the middle, my lord. The total works allotted to 53 groups. My lord has it, my lord?
Yeah.
53 groups dividing works to all different groups to execute the work within a stipulated period. The petitioner, Messrs. Karbi Project Limited, was allotted 3 groups of work, and for 50 groups were allotted to other contractors. For the works executed by the petitioner, an amount of such and such was paid, and thus total release amount for such and such lakh has been paid to different contractors. A total fund received from the government are 2662.25 lakhs. That is 66% of the total project. And my lord would see, Messrs. Karbi Project Limited has been paid 89.79% of the amount against the work executed by them.
Correct.
Yes, my lord.
So it will include the completed work also.
Yes, my lord. Lordship would kindly, my lord, 89.79% has been paid of 100%. I'm entitled to the rest, my lord, of the completed work.
But that is where the issue lies. Okay. After.
My lord, kindly, my lord, would take up the paragraph once, my lord. They're misleading the court, my lord. Completed, my lord, kindly take up the paragraph read by my lord, page 2, my lord, additional affidavit.
You see, this is a question, we cannot go into disputes with regard to factual disputes. Whether they are misleading the court or whether you are misleading the court, I do not know. Let it be decided by either by a court which can decide facts, Because this is not a court of facts.
Arbitrator, my lord, there's a clause of arbitration.
It will
My
go
lord,
for arbitration.
my lord, kindly take note, my lord. I have referred to their own document, my lord, 23, signed by the executive.
I do not
which
know.
says
This
that-
is not this has to be, maybe evidence has to be led. But this is
My
a,
lord,
this
these
is
are
not an
read
affidavit.
proceedings,
This is a
read proceedings, my lord,
photocopy.
please, I'll file it on an affidavit. I just received it.
No,
today.
it doesn't matter whether you file it on affidavit also. This is not a original document. These are disputed questions of fact, Mr.
Let
Counsel.
them deny, they have not denied that this is not, money has been paid, they have not denied, my lord. Part payment has been made, they have not denied. Their documents for work,
You go in arbitration.
my lord, work completion order has not been disputed. What they have said the limitation period. and
No,
the
they have
work has
said
been
that
foreclosed.
the work has
Where
been.
is the dispute, my
they
lord?
have-
My work I have completed. They have
Right.
not uttered a
Mr.
single
R.M. Das.
statement, my lord.
Right. I heard Mr. P. Mahanta, learned counsel for the petition.
My lord, would allow me to file this affidavit kindly. my lord. It
Also
will make a
heard
difference, my lord.
Mr.
Part of the pleading.
J.
at least, my
Chutia,
lord.
learned counsel for the KAC. And Miss M. Das, appearing for the PWD. First off. The petitioner's grievance is that despite completion of the 3 contractual works for construction of roads, the petitioner has not been paid his dues despite completing all the 3 contractual works.
I'm claiming just one, my lord. Other two,
Yes, sir.
no dispute. Payment has been made.
Okay, what have I said? Just read from the beginning. Has not been paid his dues for 1 contractual work, has not been paid his full dues for 1 contractual work, while having been paid the dues for the other 2 contractual works. So, next paragraph. The counsel for the KAC, on the other hand, submits that though the petitioner completed 2 out of the 3 contractual works, the petitioner could not complete the 3rd work.
You know, that is not
The
the
third-
stand, that is against the affidavit. That is
Huh?
what I'm trying to tell
No,
you.
no, that is not
Lordship,
that.
kindly read the affidavit for a moment, my lord. 3 words, I'll read it again, my lord. That is what, my lord. Take up paragraph 2, my lord, paragraph 3 for a moment. kindly.
Let me take it up.
Yes, my lord. 2. Paragraph 3, what do they say? 3 words. The 3rd work is number 3, the last line. They have not said that I have not completed the work. They have said I have not completed it in stipulated time. Thereafter, notice was given and I was issued work completion.
Okay. Hearing concluded, order reserved. Just put this on.
My lord, kindly read that paragraph 1.
I will.
My lord, my written argument, I'm sorry. With the case law, my lord.
Written argument is against the affidavit. Lordship would take note. The department says work has been completed, but not on time. But my learned counsel has given a written argument where he has denied what has been stated in the affidavit. Lordship would kindly take note. My lord.
Regarding the judgment, my lord, regarding the one, he has not disclosed that the work order was, his work order was
Totally
considered the second.
misleading, my lord.
Right.
Against the affidavit they are submitting.
Asha, what about 14? Item 14?
My lord, in the 14, my lord, we have terminated his contract for non.
That is not, again, Lordship has to hear it, my lord. Lordship would take in another day, 14. Lordship would not go by his statement, my lord. Lordship would go by the affidavit.
My lord, he has not denied that affidavit. We have annexed that document particular.
They filed 3 affidavits. That's
My
the
lord,
point
change the
of it.
construction, my lord.
They
Lordship will
change
look
their
into-
stand, like, my lord.
Lordship will look into, my lord, that page 47,
What have you said?
that we have cancelled the work, my lord.
That is again, I'll point
No,
it
that
out.
is
Again, a
not-
misleading statement. Right now, I can point it out.
My
There's a
lord,
lot of.
he has
Page
not filed-
47.
He has not filed a reply to that, my lord. If it is a
What is-
misleading
I don't-
statement, he
I
has to
can,
file
I
it
can
as a
show it from
false
the
statement.
record. It's a misleading statement, 47.
By mere submission in, my lord, verbally in the court, my lord, it will not suffice. He should file it that it is a document submitted to me by the.
Well, his
department.
submission ought to have been that, no, it's not misleading. What is his submission? That I should have filed an affidavit to
Lordship
say.
will look page 47, annexer to page 47.
My lord, come to
That is
page
the
47.
cancellation notice. We have specifically cancellation notice, that is the work order issued.
My lord, would come to the cancellation notice, my lord. And lordship would, my lord,
JK Construction, my
take
lord,
stern action, my lord, if it is misleading, my lord.
page 47.
Page 47, lordship would take it up.
JK Construction,
Yeah,
PWD contract, cancellation. There is a single work, my lord. So the cancellation notice in respect of JK Construction, my lord. Improvement of EBDC road from 1st to 31 kilometer under NLCP for the year 2008 from 9,000 to 14,500. And it is issued to him,
Page.
page 47.
That is affidavit, your
Affidavit, my lord.
affidavit dated. Because you see, their 47 and our 47 is completely wrong.
My lord.
It doesn't match.
It doesn't match.
Therefore, you see, their 47 is some.
My lord,
Okay.
it is filed on the affidavit filed on, my lord, 30/11/2022.
I think 14.
14.
JK Construction.
This is a letter dated 28 September,
Exactly.
28
Yes,
September.
yes.
This is the JK
page
Construction.
47.
Page 47.
Okay.
Cancellation notice, my lord. JK Construction petitioner.
Yes.
It was issued to him. Improvement of BBDC road from 1st to 31st kilometer under NLCPR for the year 2008-9 from chain to so and so. And the lordship made the third paragraph, under the above circumstances, there is no alternative than to cancel the work, and finally the work is cancelled at your risk and construction. So it is a single project, my lord. 53 groups were allotted the works. If the one person could not complete the work, the other person suffered, my lord. That is the point. No regarding misleading, whether he has completed or other completed. The stand of the, my lord, department is that as a single project, central government give, sanction the project, sanction the amount on the for the single basis, not on the
So according to you,
executive basis.
it should go for arbitration.
arbitration.
My lord, cancellation,
My lord,
lordship would take up 47 for a moment. Again, what he has referred. Kindly, my lord, to show, my lord.
Yes.
47, lordship would kindly read the subject, my lord.
Yeah.
Cancellation notice. Page 47 of the affidavit.
Yes.
Then I'll point out one page of the writ petition, my lord. Subject cancellation notice. Improvement of BBDC road from 1 to 31 kilometer under so and so. My lord would see bracket from CH 9,000 to 14,550. Now, my lord would come to my writ petition, their own document, my lord. That's why I'm saying it's misleading, my lord. He read this document to show that for the work which I'm claiming money, that work was already cancelled, right, my lord? That's for what I've understood. Lordship would take up the writ petition, my lord. Kindly.
I've got it here.
Writ petition, page 28, my lord. See, JK Construction, my lord, was allotted, page 28, my lord, there is a chart. Lordship has it, my lord.
Yes.
JK Construction has been allotted a number of works, and the work referred to in the cancellation notice is the first work. Lordship would see 9,000 to 14,550.
Yes.
Lordship has it?
Yes.
For that, I am not even claiming money, my lords. It says work in progress. I'm claiming money for the serial number 3, 4, 5, 6, 7, where they have said work has been completed. The last column, my lords. My learned friend is showing this document to show that my work was cancelled. I'm not even claiming money for that work.
My submission is that if he
Lordship
could not, if he could not complete the one work, main
Correct.
construction work, my
This
lord,
is part of the work. This is part of the whole entire work.
No,
My lord.
no, my lords, I'm not claiming money for that work.
Regarding
I'm
what
claiming
is
money
does
for
not
the
arise.
work which are completed. Lordship, kindly take up page 20 at the chart, my lord.
Yes,
My
I've
lord,
got it.
serial number 1.
Yes.
It is allotted to Messrs. JK
Correct,
Construction.
correct.
This is a different work. 9,000 to 14,550.
Yes.
There is dispute with regard to that work. I say I have completed. They say, but this is not subject matter of this writ petition.
What is the subject matter of this?
It is the last remarks, work in progress. They say.
Yes.
Yes, I say, okay, work in progress. I'm not arguing this case now, my lord. I have been claiming money for serial number 3, Lordship would see. That is a different work from 11 to 15 kilometer drain.
So 11, this is also from.
Completed. This is different work. There are different works under one project.
Which one are you claiming out here?
Serial number 4.
Do you mean to say that how many agreements do you have in respect of this contract?
Different works for my lordship would see.
No.
Lordship, kindly.
You're trying to.
There are 12 matters. Out of 12 matters, 6 matters I have already been paid, my lord. I completed work. All money has been paid. Other four also have been completed work, part payments have been made.
if you say that these are all different contracts.
Different contracts, different contracts.
So they, according to you, there are 12 different contracts as per page 28.
There are total 54. I am
Mr.
concerned with
Council,
12.
you are concerned with 12.
Hmm.
Please show me 12 contract agreements.
Yes, work
Show me.
order also, my lord, would come.
No, show me the agreements, your contract agreements. You have
My-
12 contract
My
agreements.
lord, I'll show that. My lord, come to page 22 for a moment. The first one, page 22.
Yeah. No, I want the contract agreement. Show me your contract agreement,
My
12
lord,
contract
My lord,
agreements.
if it was one work, there would have been one work completion certificate.
Okay.
I've been issued.
Mr. Council, there's a simple question I'm asking you.
Yes.
If there are 12 different contracts,
Yes.
there has to be 12 different contract agreements.
We have 12 different contract agreements.
Where are they?
My lord, I have stated, they have not denied it. This is not
No.
even in dispute, my lord.
Mr. Council, whether they deny or they do not deny, the court's asking you.
My
I'm
lord,
not asking you
that
whether
has not-
they admit or deny.
that has not been-
Do you have 12 contract agreements?
I have not annexed it. I have it. I'll produce it on the next day.
You bring it tomorrow?
Yes, I'll bring it tomorrow.
List the matter
Yes,
tomorrow, on which date
12.
the petitioner's counsel shall produce all the 12 contract agreements, in as much as he states that 12 different contracts had been given to the petitioner by the state respondent. List the matter tomorrow. I don't want
My lord,
to.
day after tomorrow, it will
Okay,
come
day
from
after
Golaghat.
tomorrow. Day after
Golaghat.
tomorrow.
I'm deeply obliged, my lord.
First, I will save you.
Very grateful, my lord. I'll produce the contract. Deeply obliged, my lord.
But
Hmm?
today morning, we have received the instruction, my lord.
15, 16 days.
My lord, 1 week time given earlier.
lord, I have
Who was
objection.
appeared in this matter, my lord.
I have a serious objection, my lord. Kindly see the order dated.
I know, no,
My
I
lord.
know. No.
21st of August, 23, 11th
You
of
see,
October.
madam, final opportunity has been granted 1, 2,
Three.
3 times.
My lord,
No,
this
no,
was-
no.
Is not well, my lord.
No.
Kindly
Okay,
allow
no.
1 day time.
No,
My
not
lord,
time. Heard, Mr.
Eighth house, admitted amount.
Eighth
my
house.
lord. Eighth house.
Learned
My lord,
counsel
this
for
was
the
received
petitioner.
today.
Okay, then we'll reflect this. That's enough.
It's the second round of litigation, my lord.
My lord, kindly allow me 1 day only. Day after tomorrow, my lord. My lord, tomorrow. My lord, kindly the matter may be taken up tomorrow, my lord.
Just look at this. They're neither here nor there.
Yes, my lord. In fact, it's an admitted, they're admitted documents, admitted.
Please look at
liability.
this. I'm giving it to you. Just take a photo of it. Otherwise, you're not. On the prayer of the petitioner's counsel, no, on the prayer made by Miss
M. Das, my lord.
M. Das, the counsel for the PWD, list this matter on Wednesday. Wednesday. You just look at it. So you'll be filing affidavit when? Today? Tomorrow? Tomorrow. Miss M. Das, submits that she'll file affidavit in opposition tomorrow as she has received parawise from me.
Deeply obliged.
Apply.
Definitely tomorrow.
17.
Matter pertains to non-payment of the bills, my lord. The petitioner's two vehicles were, my lord, put on, my lord, used by the Assam police, my lord. So far in respect of, my lord, page 12 and 13 is the requisition notice. My lord, whereby two.
No, Levy, what have they said? Have they
My lord,
admitted?
In respect of one vehicle, they have admitted and in the affidavit, they have mentioned about the same. But in respect of vehicle at page number 12, my lord, annexure 1, there is, they have not admitted that bill. Partially, they have.
So,
admitted,
so whatever they've admitted, you take that. What else can be
And
done?
so far as the other part, my lord, they, in the RTI, before the State Information Commissioner, my lord, the authorities, they have admitted both the amounts, but in the affidavit, they have partially.
What to do? This is only this is a writ petition. We
Let
cannot.
them examine in respect of the other vehicle.
Then in other vehicle lordship, page 24, my lord may indicate page 24 lordship. Page 24 order lordship, that's also is a.
Page 25.
Page 24 here.
Page 25, it's reflecting lordship. Point 12 also lordship.
Huh?
Point 12 lordship. Page
12, yeah.
25. Here it is reflected there are two vehicles lordship, two bills lordship, but lordship in the affidavit in page 57 lordship, it's admitted amount is lordship 526300. So my lord may direct the responding authority to examine the matter in the light of the page 24 as well as lordship the admitted amount that is in page lordship 57 lordship. Otherwise, it is there lordship, but the admitted amount as per the affidavit is only for lordship 526300.
No. Why should we ask them to verify again and again?
Otherwise,
Why should we ask them to verify again and again? Let him.
admitted amount lordship may direct the authority to.
That's what.
No, my lord, they have annexed all the bills, my lord. Out of those bills, my lord, this amount they have mentioned,
You go to the civil court.
but in the RTI reply, they have admitted it, my lord. Before the commissioner, they have admitted the amount.
Mr. Counsel, we can only go by what is admitted in the affidavit.
Not before the
Those-
commissioner, my
those-
lord, they
those-
have produced the records.
Mr. Counsel, that is the
Paragraph
law. We
11,
cannot-
12, 13, in 4 paragraphs, my lord, they have clearly, 2 vehicles were there, my lord. My lord, paragraph 11, my lord, will see page 25.
This is a writ petition. This is not a civil court.
And my lord, what they have said in affidavit is only
I
about.
heard Mr. H. Gupta, learned counsel for the petition. Also heard Mr. K. Gogoi, learned government advocate. Agreed by non-payment of outstanding dues for hiring the petitioner's vehicles bearing registration number AS 13/B-0734
No.
and AS 01 AH 0887. The petitioner has filed the present petition. Full stop. The petitioner has relied upon the order dated 30/03/2022 passed by the Assam Information Commission and the letter dated, where is that? SPIO?
Lordship, page 24 lordship.
That is the letter, my lord. Page.
The
State Chief
has-
Information Commissioner has passed.
has relied upon the order dated 30/03/22 passed by the
State Chief.
State Chief Information Commission,
Commissioner.
Commissioner. Is it? It's not State Chief.
No, state.
State Chief Information Commissioner. For payment of his bills amounting to rupees,
My lord, 10 lakhs, my lord, in the writ petition, we have claimed 10 lakhs, my lord.
amounting to rupees
10 lakhs,
12,90,549. Which were allegedly sanctioned way back in 2012-13. Full stop. Next paragraph. The respondent number 3 has submitted an affidavit wherein, where is that admitted amount?
Lordship, page 57 starts and page 58 is there, page 57.
Wherein the letter dated 18/6/2022 issued by the Deputy Commissioner of Police bracket ADMN, Guwahati, has been annexed. The same shows that they have admitted that rupees 5,26,300 is payable to the petitioner. Next para. I have heard the learned counsel for the parties. In view of the admission made by the respondents to the effect that the petitioner is liable to be paid rupees 5,26,300, the respondents are directed to pay the same. They are directed to pay the said admitted amount within a period of 2 months from the date of receipt of a copy of this order. So, sir. Now, what about the rest?
My lord, in respect of the vehicle number at page 12, my lord, they may examine, my lord, because in the RTI, before the commissioner, they have admitted the amount. In the affidavit, but they will examine it and.
First up, in respect of the bills claimed in respect of
My lord, page 12, my lord. Vehicle number-
AS 13B0734,
My lord.
comma. Which authority?
My lord, it is the Assam Police, my lord. Deputy Commissioner of Police Administration.
That's the respondent number.
See, Lordship.
Respondent number 3 shall verify the claim of the petitioner, keeping in view the order dated 30/03/22 passed by the State Chief Information Commissioner Assam. Thereafter, any admitted amount found pending against the petitioner should be paid to the petitioner. The said exercise should be concluded by the respondent number 3 within a period of
4 months.
4 months from the date of receipt of a copy of this order. In case there are any amount not in the event the petitioner is aggrieved by the order passed by the respondent number 3, he may approach the appropriate forum for redressal of his grievance. Any other appropriate forum? Any other appropriate forum? Accepting this court for redressal of his grievance.
My lord, sorry, my lord. Item 13 and 14, my lord, both are analogous matters, my lord.
13 we're disposing.
It may lead to some inconsistency also. Both the matter, let it come, my lord, on
No,
day
no.
after tomorrow.
Let us take 90. What is it? 18, 18. 17. Okay. 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 Yeah.
Your Lordship.
Yes.
Lordship, on Friday, my lord has heard on land. My lord has asked me to file it as an IA, my lord, with regard to the SOCOS notice, my lord. My lord, I take your lordship to Annexure 2, page 16 of the IA, my lord. My lord, what happened was that 80.
Huh? What is the IA about?
IA is with regard to a SOCOS, my lord, which was issued to me during the pendency of the writ petition, my lord. My lord, the
Where is the show cause?
Annexure 2, page 16. My lord, the cause of the repetition was that, my lord, most of the lands after the grant of the lease, my lord, was inaccessible, my lord. So we have filed various representations. Not even a single representation was considered, and the matter was first notice was issued on 12th of January, which is I have Annexure 1, page 14, my lord. Page 14. And my lord, the next date was fixed on 2nd of February, my lord. What happened was that on 1st February, my lord, that at Annexa 3, page 19, my lord.
So have you submitted your written
No, my lord.
by?
My lord, on 2nd of February, the case was fixed, my lord, before this honorable court. On 1st of February, Annexa 3, page 19, my lord. At around 3 p.m., they have served us the SOCOS notice. Annexa 3, page 19. Annexa 3, page 19, they have served us the SOCOS notice, my lord. My lord, the case was that after the grant of lease, my lord, so out of 2789 bighas, my lord, only accessible land was 759 bighas. We have been filing continuous representation.
Yes, Mr. Karida.
Lordship, I am appearing for the department, but the SOCOS notice was issued by the ATCL, this Assam Tea Corporation Limited, there's a different organization altogether. But Lordship, as far as this lease is concerned, Lordship, the lease has a clause of arbitration. That is a business deal, Lordship. I mean, after the lease was entered, they must have verified all these aspects. It's a business deal between the ATCL as well as the party. Now the lease has an arbitration clause. So if there is any dispute, they could have approached there. And now SOCOS notice is issued and by ATCL, but like there are some time now that they can reply to the SOCOS notice. Lordship.
My lord, the thing is that, my lord, the
You
lease,
file,
My lord.
you take a sub, you file your thing.
my lord, the lease is of 30 years, my lord.
Maybe.
Yes, my lord, with regard to my lord, I have filed my representations, highlighting every issue with regard to, my lord, what I
So whatever you file a reply, whatever you have stated in your representation,
My lord.
you file a reply to the show cause
My
and
lord,
let it be decided.
My lord, but my lord, no adverse, my lord, with regard to.
Then yes, we'll give you a short date,
Yes, my lord.
short date till you take a decision.
My lord, that is, and for that I am praying for an interim stay and for the notice.
No interim
And-
stay, no interim stay, no interim.
Because, my lord, on Wednesday, my
Ah.
lord, the matter was fixed on Friday before this honorable
Ah.
court. It came up before this honorable court also. My lord has heard on them also on that day.
No, but then who are the parties here?
My lord, the
ATCL is the main party, Lordship.
ATCL.
Oh.
ATCL. And so what they did was on first.
Do
at-
the ATCL know about the pendency
Yes,
of this case?
everything, my lord. At 3 p.m. of 1st of February, that is what I was saying. Annexa 3, page 19, my lord.
Just a minute,
And my lord, in my IA,
just a minute. You have not taken steps.
my lord, I have taken, it is reflected on immediately on that day itself. It is, I have seen, my lord, verified. I have seen the records. my lord. On that day itself, on 12 itself, I have taken steps on very date. And my lord, I have even categorically made statement in my IA also that they are aware. My lord, interestingly, on Friday, the matter was before this honorable court. I had a meeting, I was called by the MD in his office on that day itself also. On that day also, he was aware of this matter pending before this court. Matter was fixed on 2nd. On 1st at 3 p.m., this notice was issued to me. That is why I'm projecting Annexa 3 page.
This is on 1-2. And today is,
Today is 5th, Lordship.
Fifth.
5th. They could have replied
on-
sort.
you reply to this?
My lord, my lord may grant me some days and like some protection, my lord, because my lord may kindly see the notice because my lord, my issues are pending. my
Ah,
lord.
you have been given how much time?
7 days from Thursday.
From 7 days from Thursday.
Means from first I'm given 7 days.
And you file this when?
Repetition.
No, this affidavit on 5th.
My lord directed me.
Today, you filed it today.
My lord directed me to file today. On Friday, actually, my lord was about
You-
to dispose this matter to grant, consider it to the representations along with this protection till SOCOS till a decision was taken. Then my lord has, since they objected for it, they prayed for an IA, so my lord granted me time today to file this IA.
So we'll give you 1 week from today.
Yes, let them
You
serve.
file for that 1 week. For that 1 week, we'll give you protection.
My lord. And my lord, the representations, everything are pending. With
No,
regard
no, no, you file, you put all the issues that you have raised in your thing, you put it in your show cause reply.
My-
That will suffice. Otherwise, if there is a arbitration clause, then
There is an arbitration clause. There is an arbitration.
you see, that is one thing you'll have to look into, right? Heard, Miss
LC Bolwa.
S.G. Barwa. Huh? In the main case. Huh? Two main cases. So, basically, one case is similar.
Similar.
Huh?
Similar, my lord, both are same.
All of them dispose of together, huh? Heard Miss S.G. Barwa, learned counsel for the petitioner. So it's both deep link tea estate or
One
different?
Deep Link and one Rajabari tea estate, two tea estates.
Okay. Then you take para 2. Did it say like this? Heard Miss S.G. Barwa, learned counsel for the petitioner. Also heard Mr. A. Kalita,
As for now, one loss.
for point number 1, and Mr.
And for response number 5, M. Setia.
Miss G. Hazarika for response number 2, and Mr. M. Chetia for response number 4.
4 months.
4.
4. No one appears for the respondent number 3. That is the Assam Tea Corporation Limited. The petitioner's case is brief is that pursuant to a request for proposal floated by the Assam Tea Corporation Limited, the petitioner participated in the same and was duly handed over the possession of the Deepling Tea Estate on lease for a period of 30 years. On when?
Physical possession on 1/4/2023.
1/4/23.
Physical possession.
Physical possession, huh? Physical possession. The next para, the grievance of the petitioner is that after taking over physical possession of the tea estate, it was detected that large portions of the tea estate were under encroachment and that there were extra number of workers over and above the list supplied by the Assam Tea Corporation Limited at the time of taking possession,
My lord.
taking physical possession of the tea estate. In view of the same causing immense difficulty and hardship to the petitioner, the petitioner submitted various representations to the authorities. However, the respondent number 3 has not considered the petitioner's representations till date. Next paragraph. The counsel for the petitioner submits that despite the above facts, the ATCL has issued a show cause notice dated 1/2/2024 to the petitioner for determination/termination of the lease granted in favor of the petitioner and has given the petitioner 7 days time to submit a written explanation to the same. Next, Mr. A. Kalita. No, the counsel for the respondents on the other hand, submit that as the petitioner has been given a show cause notice by the ATCL, the petitioner should submit her reply to the said show cause notice. Pusa. I have heard the learned counsel for the parties. The prayer of the writ petitioner is for a direction to be issued to the ATCL to consider her representations which she had submitted time and again, which she had allegedly submitted time, which the petitioner had submitted time and again. Pusa. As the show cause notice dated 1/2/2024 has allegedly been given to the petitioner only on
First February
has been given to the petitioner on 1/2/2024
in the email at 3 p.m.
in the
Email of the petitioner.
in the via email, this court is of the view that the writ petition can be disposed of by giving liberty to the petitioner to submit her reply to the show cause notice, wherein the petitioner can incorporate all the issues and points raised by the petitioner in the petitioner's representation. Full stop. Accordingly, the petitioner is given liberty to submit a reply to the show cause notice dated 1/2/2024 on or before. Today is what date?
Today is 5th.
On or before 12/2/2024. To the
ATCL, respondent number 3.
to who has issued the notice to the
Respondent number 3.
managing director, ATCL. Full stop. If till a decision is taken by the respondent number 3 to the reply made by the petitioner to the show cause notice, no coercive action should be taken against the petitioner pursuant to the show cause notice. Full stop. The above is, however, subject to the condition that the petitioner submits reply to the show cause notice on or before 12/2/2024. The writ petitions are accordingly disposed of.
The subject matter of 52 and 53, my lord, is little variation in 53, my lord. My lord has projected his case of 52. 53, the issue is out of 2789 bighas, my lord, only accessible land given
2789 bighas.
Two kothas, 15 lessas.
Yes.
I was only given physically, I was only given land of 759 bighas, 2 kothas, 10 lessas. There is no mutation and in the name of ATCL. There is no mutation in the name of ATCL. They have given the land on lease without having their names mutated.
And that issue of worker is not there.
No worker.
It's only with regard to the land. Only this much land is given to you.
Here, my lord, enforcement part is also
But there,
there. Enforcement part is there. I am only given the whole RFP. It was issued 2789 bighas, 2 kothas, 15 lessas, out of which I was given only 759 bighas.
Physical possession.
Physical possession.
But is it
Yes,
written?
Written, my lord.
Then?
Yes. And no, my lord, it is on record through representation.
So you should be given.
And interestingly, my lord, after possession, I came to know that they have given on lease the whole land. I have spent everything. Names are not mutated in their names. They are going in process. Okay.
Their names
are
they've given you 2789.
Yes, no, my lord. They have given on RFP 2789.
RFP meaning?
Request for proposal. Yes, my lord. And I'm only given physical
actual possession you've given only 759.
bighas, my lord. This is the issue.
Okay, right. Heard so, same thing, I think.
My lord, by
Full stop.
the same.
Then you write, the grievance, the case of the petitioner is that pursuant to a request for proposal quoted by the Assam Tea Corporation Limited, bracket respond number 3, comma, the petitioner took part in the selection process for taking possession of the Rajabari tea estate, allegedly comprising of 2789 bighas, comma, 2 kathas and 15 lechas of land. Full stop. However, the petitioner was given actual physical possession of only 759 bighas, 2 kathas and 10 lechas of land. Full stop. Further, there has been encroachment on the land which has been given to the petitioner by the ATCL. The next para, the petitioner's counsel submits that though the petitioner has written various representations to the respondent number 3, the respondent number 3 has till date not considered the representations of the petitioner.
My lord, and mutation and demarcation issue is also there.
Full stop. Next para. The petitioner's counsel further submits that the
That the mutation.
that the land which has been given possession of
This, that is.
has been given though the land has been given a lease of 30 years for the said land, and actual possession of the same was to be given for 2789 bighas, 2 kathas and 15 lechas of land, comma. The petitioner
Mutation process.
has come to the knowledge that the land has not been mutated in the name of the ATCL till date.
And they are in process.
Further, the mutation process is still an ongoing process which has not been completed in favor of the ATCL till date. That's all.
My lord.
Full stop. Next para. The petitioner's counsel further submits. Any show cause out here? Reply? No.
No.
Okay. And the petitioner's counsel submits that the respondent number 3, bracket ATCL, should be directed
My
to.
lord, the same so cause was issued for both the pieces.
Acha. Then you write the same thing. Then you write the petitioner's counsel submits that on 1, 2, so, same thing, except it will be out here, Rajabari tea estate. Okay.
Obligement.
That part will be same.
Obligement.
Dispose of. In the IA, right, in view of the order passed also, things pass, dispose of accordingly. In view of the order passed in the main case.
My lord, this is for the appointment of arbitrators.
For appointment of arbitrators.
Yes, my lord. And there is no dispute about the arbitration clause, my lord. The agreement contains an arbitration clause, my lord. And as they failed to appoint the arbitrator, my lord, in terms of the agreement, the petitioner approached the President Institute of Engineers at page 83, annexure 18, my lord.
Where is the arbitration clause?
At page 51, my lord.
Clause number 25.3. And in my case, my lord, 25.3F is applicable.
Huh?
25.3F is applicable, madam. Because here the value of the contract is about 2 crore. So here there is a provision.
The sole arbitrator.
Sole arbitrator. Accordingly, my lord, I approach the
So I
respondent.
think you have agreed to it also in your affidavit.
Yes, yes.
So-
Page 78, in fact, in 2016, we have suggested them to choose one from the panel. Page 78,
78
of the petition,
of the petition?
of the arbitration petition, page 78, Annex
78.
16.
Okay.
We have suggested them the name. They have not.
No, but then your issue is with the PWD, correct? Then this cannot, this cannot be,
Yes,
cannot.
yes. Page,
I think Eastman Perkins.
Yes.
page 92 again, my lord. Thereafter, he was appointed,
92.
92.
92?
Last page.
Page 92, Annex 21.
No, we do not know. High Court has got its own list.
Yes.
Now who do you want? We have got,
List or list.
we have got a list. You choose both of you. If it can be agreed, very good, very good.
Honorable Justice, yes, sir.
Sure, sure. Okay, right. Heard Mr.
Sir.
R. Hussain,
Yes.
learned counsel for the petitioner, and Mr.
I'm Tina,
Dinas for the
respondent.
all.
All.
For the respondents. Full stop. This petition under section 11(6), is it?
Yes.
11(6)
Yes.
11.
of the Arbitration and Conciliation Act, 1996, is for appointment of an arbitrator to decide the dispute between the parties in terms of clause 25.3
.3
bracket
AF.
F. Page
Page, my lord, 51, starts from 51 and F is available at page 52, my lord,
F.
where the value of the contract is 50
uh,
million. And below,
F.
52, my lord.
Of the, what is this? Of what? Of
Of
the,
agreement,
of the
contract
contract agreement made between the parties on
28 to 2000.
28 to 2030. Full stop. The the now the pursuant to a tender dated 1/9/2000, what, 2013, what,
Yes, my lord,
2013. A contract agreement dated 28 to 2013 was executed between the parties for the work upgradation of Mokal Mua Adatari via Narayanpur Road in Nalbari district. Bracket package number AF-NL-7 bracket close at a total cost of rupees 2,09,30,683.00. So this is at page para 4 of the writ petition. Para 4, huh? So then what has happened? How did it contract?
After execution of the contracts, they
Contract was completed?
no terminated.
Terminated.
It was terminated.
Full stop.
They
In-
completed 10% of the work.
Huh?
Less than 10% of the
Full
work.
stop.
they have done.
As the contract of the petitioner, as the contract awarded to the petitioner had been terminated, the petitioner being aggrieved by the same has now correct?
Yes.
Has now prayed for invocation of the arbitration clause to resolve the dispute between the parties. Gustav. Mr. D. Nath, learned counsel for the respondent submits. He has got no objection to the prayer of the petitioner's counsel for grant for invoking the arbitration clause in view of para para 15 of the affidavit in opposition.
Yes.
Correct?
Yes.
Wherein it has been stated that the appointing authority does not have any reservation on appointment of a sole arbitrator. Gustav, next para. Clause 25.3 bracket F of the arbitration agreement, of the contract agreement between the parties states as follows. Page 51 and 52. Next. Then that other arbitration agreements we have done, no? Say, other arbitration agreements we have done. That in view of notification number 99, I think. Is 99?
Yes, my lord, 99.
Notification numbers 99 says so. C.R. Sharma. Huh? So Justice C.R. Sharma.
But as per clause, as per section 12(1), possibly his consent is to be.
No. You see, what has happened is not his consent basically. His consent is one, and plus whether he can take up or not, that you two decide. You two take up the communication with him. What we are going to appoint him, this court will appoint him, giving liberty to both of you to communicate with him thereafter with regard to whether there's any bar under section 12 for his appointment under thing. So if he decides that, then you come again, we'll give another name.
Yes.
Otherwise, it will be a problem. We'll have to
Yeah.
wait for his communication. That's the problem. Okay.
But
Dispose of. No, it's there in the order, that the various orders.
here
I
also,
think
my lord.
Yesterday you made, na? Remember, yesterday is there, in that thing, those two orders.
Here, my lord, I have annexed the agreement, my lord, but due to mistake, my lord, the arbitration clause is not annexed here.
Show me, have you got separately? Is there an arbitration clause?
No, my lord.
There's no arbitration clause.
They have already taken steps denying for appointing the
We have
arbitrator.
already sent even though we have sent a panel, my lord, for arbitrator, my lord.
They want their own
But
arbitrator.
they declined.
You cannot have your own
Yes,
arbitration.
yes, that is.
That's for sure.
But there is no clause, my lord, for arbitration.
On
No,
Friday,
I'm not on that.
Yes, yes,
You see, just because there is no arbitration clause doesn't mean that you cannot go for
yes,
arbitration
yes,
clause.
my lord.
If you want, you can go.
Yes.
So do you want to go for arbitration or not?
My lord, this, our affidavit, last page, last, my lord, paragraph, page 6, 86, my lord, paragraph 19, my lord.
Page 86.
Yes, my lord. Begs to state that the purpose and entire inter-contract agreement is to settle arising to specifically six. To say the condition prescribed in so and so. We have a partner fund. Yes, yes,
To
yes,
settle dispute arising through arbitration.
Yes.
Then,
yes. That's it, my lord.
especially clause 63, 64.
Yes, ma'am.
Now, what does it say, 63, 64?
See, if this, so we can, my lord, appoint, my lord.
Was your contract terminated?
yes, my lord.
Contract
No,
No,
In this case, not
It's got everything, my lord, only the price.
Price variation.
Price variation.
price
It was-
escalation.
Yes.
It was.
Escalation, yeah, what?
Price is.
Cost escalation, price escalation, what?
Price escalation. my lord.
Price escalation.
Yes.
So you have made a claim for that.
And SD money is also there.
A security
Security
deposit.
money. Yes.
Security, money and price escalation.
Price
It was already, my lord, it was, my lord, given, my lord.
Huh?
It was, my lord, paragraph 8, page 84, my lord.
Security deposit,
Yes,
already paid.
yes, my lord. Only price verification, my lord, is rejected, my lord.
Okay, price escalation.
Yes, sir.
So you go for arbitration.
Because this settlement will.
Okay, huh? Yes.
Only my lord, your lordship may appoint the arbitrator because the arbitration agreement is there, my lord. And they.
No, but that's what. You see, the thing is that I want to see what is written in the arbitration clause.
Yes, yes.
Because if there is a provision there stating that the arbitrator will be a person from GREF or appointment will be made by the GREF authority, we will have to set aside that portion. I have to
My lord,
clarify that.
No, there is no such.
On Friday, your lordship may take it.
Huh?
On Friday.
There is no such agreement.
No, but there is an arbitration clause
Clause is there, my lord. I will show.
because it says agreement, the petitioners makes to states that the petitioners entered into a contract agreement to settle dispute
Yes.
arising therein through arbitration, specifically clause 63 and 64 of the general clauses of contract. So it is there
Your
to
lordship.
say the prescribed in consonance with Act of 1996. That is only the Arbitration Act.
Yeah.
Then what
Your
else?
lordship might kindly see the page number 78. Their reply is there. They wanted their own officer to be appointed. It is not permissible, my lord. At page 78, my lord.
Okay, we can dispose of. I can
Yes.
mention that.
Yes.
This man. Not a problem. Page 78.
Yes, 78. Now their party, they cannot appoint the arbitrator, my lord. And their own officer cannot be appointed arbitrator.
Cannot be appointed.
Yes, this is well settled law. My lord. Your lordship may appoint the arbitrator.
Who? Who do you want? The High Court judges, there are only two as per the list.
Yes,
I think this has to be expanded.
yes. Yes.
Just remind me, Anupam, we have got to expand this list of arbitrators. Only Justice Sharma and Justice H.N. Sharma and Justice C.R. Sharma. We need some more. We have got Bujar Barwa, we have got Justice Kataki, Bhattakur.
My lord, yes.
Who?
District judge.
District Judge?
Yeah.
Okay,
Srimati Shahrani.
okay,
Goswami.
okay, right. Heard Mr. Sema and Mr. S.K. Medi, Leonard CGC. This is an application under section 11(6) of the Arbitration and Conciliation Act 1996, hereinafter referred to as the 1996 Act, by which the petitioner has invoked the arbitration clause for settling the dispute between the invoked the arbitration clause in the contract agreement executed by the parties for settling the dispute relating to
Relating to my lord.
where is that work?
Yes.
Relating to
At page 2, my lord. But
relating to
For the
the
performance of-
relating to
Page 2, my lord. First time. For the performance of the work, manufacturing and supplying of.
relating to the manufacturing and supplying of inverted commas, manufacturing and supply of 50 mm size machine crushed ballast, BALLAST, at Jorai Depot under Alipurduar Division
Alipurduar.
pursuant to NIT number 14/1 of 2014, dated 19/11/2014. Next para. The petitioner's counsel submits that the petitioner has completed the work which was allotted to him in pursuant to the tender notice dated 19/11/2014. However, as the petitioner was not paid the security deposit and price escalation of the material supplied, comma, he
It was released, my lord.
he invoked the arbitration clause. Full stop. However, in the meantime, the petitioner has been paid.
No, my lord, I have no instruction.
Okay, full stop. Don't say it. Full stop. There. Next para. He accordingly, no, correct, continue. Full stop. He accordingly submits that the petitioner, he accordingly submits that this court should appoint an arbitrator as the arbitrators that have been proposed by the respondents are their own officers, are their own railway officers. Full stop. Next, Mr. S.K. Medi, learned CGC, submits that the security deposit payable to the petitioner has already been released to him.
Earnest money and security deposit.
Huh?
Earnest money and security deposit.
Earnest money and security deposit have already been released to the petitioner, as has been reflected
Paragraph 8.
in paragraph 8 of the affidavit in opposition filed on behalf of the respondents on 20/12/2023. He submits that yes, what is your submission?
Regarding my lord.
Do you want the arbitration to be done or not?
My lord, actually, in last paragraph 19, my lord, there's.
It's contradicting itself.
Yes, madam. So, yes, madam. So that is there, madam, I cannot.
Yeah.
Beyond.
He submits that in view of para 19 of the affidavit in opposition filed by the respondents, comma, disputes between the parties would have to be settled through arbitration
So for various.
in terms of the 1996 Act. Full stop. I have heard the learned causes for the parties. Full stop. As can be seen from the pleadings, though the arbitration clause has been invoked by the petitioner, comma, there has been a stalemate with regard to appointment of an arbitrator. Full stop. As such, this court is of the view that an arbitrator would have to be appointed in terms of clause 11(6) of the arbitration of the 1996 Act. Full stop. Next para. In respect of the proposals put forth by the respondents for appointment of an arbitrator who is an employee of the railways, Indian Railways, comma, this court is of the view that the persons proposed to be appointed as arbitrators cannot be interested persons in terms of section 12(1) of the 1996 Act, read with the law laid down by the Supreme Court in the case of Eastman Perkins.
Yes.
Huh? So then at the next you write, who do you want, Mr.?
Srimati Chaya Devi Goswami.
You write that, huh? That we'll put it. You give that as per notification, so. You get the name, huh? You give us that. You just let him see the name. No, here.
Retired district.
Only one thing just come to my mind. Under section 11, is it required for the Chief Justice to appoint a particular judge to appoint arbitrator?
Retired judge.
No, no, not.
To decide cases of 11-6. Does the Chief Justice have to constitute a particular court or appoint
Earlier
a
it was,
particular court?
earlier it was. There.
Earlier it was there,
Now
long
it is
time back I remember.
Now,
it was
now
there.
it is not.
It's not there. Now anyone appoint.
Anyone.
Earlier it was. There.
Earlier it was there, no? I remember a long time
Yes,
back,
yes, yes.
around 6-7 years back it
Yes,
was there.
one case in my Kohima also, some for that matter, it was pending.
Ah.
Subsequently, madam, it was, there is another notification.
Okay,
Highly of it.
I'll give you.
In this case, my lord, the petitioner in person conducting this case, my lord. On several occasions, he was absent, my lord. Your lordship, kindly have a look on the last order of this court.
Okay, right,
1919 1 2.
right. No one appears for the petitioner. As per the cause list and the orders passed by this court, the petitioner has been appearing in person on earlier dates. First up, however, the petitioner has been absent on the last two dates, on the last two consecutive dates. That is on 21/12/2023 and 19/1/2024.
And also today.
It is also reflected in the last order dated 19/1/2024 that in case of further non-representation on behalf of the petitioner, appropriate orders would be passed by this court. In view of the fact that the petitioner has not appeared for 3 consecutive dates, this court is of the view that the petitioner is not interested in pursuing the matter. Mr. A.K. Datta, learned CGC, appears for the respondent. The writ petition stands dismissed for non-prosecution. Okay.
This is regarding the payment of materials supplied by the petitioner.
Yes,
Your lordship, part payment has been made, your lordship, and
part payment has been made.
and this has been admitted by the respondent in their affidavit also, your lordship. Now they have come with a plea that supply order has not been issued. And that's scheme for which the payment has been made, your lordship, and within the same scheme, your lordship, some payment has been made and some. I have categorically stated in my writ petition, your lordship, specifically mentioning.
Yes, is this part payment made?
Yes,
Yes, my lord. Have not mentioned, my lord, no part payment has been made, my lord.
Yes.
Actually, my lord, it is a disputed amount, my lord. No
Hey.
supply order was issued, my lord.
in the affidavit,
No
paragraph
report
6.
is there.
mechanism.
Yeah, that supply order has been issued to the petitioner, my lord.
So whether part pay, how much was given to you?
26 lakhs, your lordship.
26 lakhs
Yes, your
by way of check.
through electronic funds transfer method, your lordship.
Huh?
In their affidavit, they have stated in paragraph 6, your lordship.
Paragraph 6.
And I have the bank statement also I have given, your lordship. Now they have come with a plea that records are not available in the paragraph 8 also.
Yes. What is this? You have paid partly.
Some amount has been paid, my lord, it is not.
Some amount has been paid. On what basis have you paid? Out of thin air?
Yes.
Huh? You see, if there is no bills, if there is no supply order,
Yes.
how can you have made part payments?
There have been some orders, my lord. This amount is disputed, my lord.
What amount has been disputed?
With the petitioner has claimed in this.
How much has he claimed?
But that is also not specific, my lord.
I have annexed the bills, your lordship. Along with that.
Mr. Council, first of all, how much, how much is your dues? What is the amount?
Amount is 52,90,498.
52,
52,90,000.
19, 19,
498.
498. So this is the due amount
Due amount.
and you have been given?
Given 20. Total 26,36,420.
26 lakhs,
36,000.
36,000,
420 rupees.
420. You have been paid this. Now what to do? But then these are disputed questions of fact.
Yes.
Regarding the same kind of issue, your lordship, this honorable court referred the matter to the commissioner secretary, your lordship. I have one. There also, your lordship, balance amount was not paid, your lordship. Paragraph 8, your lordship.
8.
8.
Have they taken the ground that there's no supply orders in this case?
No, your lordship.
Then
That was.
how is he going to verify? How is he going to verify? But then how did you pay the 26 lakhs without any supply order?
My lord.
You give him some, again some more. How did you do that?
His bills are entered in the electronic MJ.
Huh?
It is difficult. Yes, my lord. Some amount has been paid, my lord.
Ah.
It is admitted.
Yeah, then on what basis did you pay? What? He promised you what?
Actually, my lord.
One rasgulla or something or what? Huh?
Paragraph 8, my lord. Plus, there's some records, my lord. That officer, he has been transferred, my lord. And
Maybe.
maybe.
Then if someone gives money, government money, on the basis of zero record, you're going to allow it. If you find that there is nothing wrong with it,
No, as
you
per-
give him some more.
Yes, my as per, my lord, paragraph 8, my lord, there is some records was available, my lord, earlier. But whole record was not produced before, submitted before the authority. There are some records, my lord, as per.
But another thing, how did you supply in the absence of any supply order?
I supplied your lordship and on the basis of the supply bills are being produced.
Mr. Council,
And bills have
your
been-
bills have to be made on the basis of some order. Where is that order issued to you?
Not the next.
Where is the bill? When supposing you are asked to supply 5 chairs to an office. You will supply 5 chairs on what? On the oral orders passed or on the written orders?
After the supply has been made, your lordship, bills are produced before the block development officer.
Mr. Council, that much I know. That much even I know. That much even I know. After you supply, you have got to submit bill. I am asking you, prior to supply, when you're going to supply, are you going to supply on the basis of oral orders or on the basis of written orders?
Or obviously written order, but the bills I have not annexed your.
You know, so
Uh,
you
the
annex.
supply order have not been annexed, your lord, but the admitted
You-
bills.
So you show us the supply order. Where is it? Where is the requirement that you have been given supply orders?
In the,
Where have you stated in your writ petition? This is basically he must be your friend, that fellow. Right? While sitting having tea and what? Some biscuits in some place, they almost have said, okay, let's supply this much. Nothing.
I have stated, your lord.
Since now it is a disputed question of facts, it's
Huh?
since disputed question of facts is involved, my lord.
Question of?
Disputed question of facts, my lord. Whether their order has been issued to him or not, that is also not in the official report.
Mr. Counsel, you have got no right to say anything actually. How did you pay him money? What is the basis? How did you pay him money? There's no record.
In paragraph 6, Your Lordship, I have stated.
Yes, what have you said?
Petitioner begs to state that being a registered supplier, it has supplied materials for implementation of the following MG and Rega scheme in Manipur, Niskot, Gao Panchayat, Jamira Gao Panchayat, Tillarpur, Jalna Chora Gao Panchayat, Cholai Bagan Gao Panchayat, Boldaboldi.
But where is the supply order?
Who mentioned about the supply order?
Where, show me a document where you are a registered supplier.
Yes, Annexure 1.
Annexure 1.
It's trade license.
Mr. Counsel, this is a registration with the GST. This is a GST registration. How are you a registered supplier with the government for supply of certain materials? How? On what basis?
I can produce you.
You get nothing. You will not have anything.
But
Right.
admittedly, they have paid my payments.
Huh?
Admittedly, they have made part payments.
You see, everything is done orally. So you carry on doing that same procedure. No point coming to court. It was done orally. So you do it.
But Your Lordship, in the MJ and Rega website, Your Lordship, my bills has been entered, Your Lordship, against the scheme. And this has not been disputed by the other.
But now they are disputing.
On the basis of this bill, Your Lordship, some payment has been made. So admittedly, so implied it, they are admitting.
The only way out, I find, is you do a verification and give whatever, because, and then for any amount that is not given, if he's aggrieved, he go to civil court.
Yes.
That's the only way out. There's nothing. You don't have any documents. They also have got no documents. So basically, both of you must be having chicken tandoori together in the evening. Oh, I don't know. And nothing is there in the records. Right. Heard Mr. K. Mira, learned counsel for the petitioners. Also heard Mr.
M. Setia,
M. Shetya for
respond number 3.
respondent number 3.
Yes.
While Mr.
For 1, 2, 4, 5, and 6.
1, 2, 4, 5, and 6. The petitioner's case is that the petitioner number 1 is a proprietary, is a proprietorship, and the petitioner number 2 is a proprietor of the said proprietorship firm. Proprietorship firm, huh? The petitioner's counsel submits that the petitioners deal in supply of materials to the government for implementation of the MGNREGA schemes under the Panchayat and Rural Development Department. The petitioner's counsel submits that the petitioners had supplied various materials to the respondents and in particular to 25 schemes that is listed in section in para 6 of the writ petition. Next para. The petitioner's counsel submits that the petitioner submitted various bills to the petitioner, to the respondents. However, the respondent authorities cleared only 15 bills amounting to rupees 26,36,420. Full stop. The balance amount of rupees 52,90,498.
9 bills, Your Lordship, here.
The balance unpaid amount of 52,98,498 comprising of 9 unpaid bills have not been paid to the petitioner till
9
date.
bills cleared.
Have not been paid to the petitioner till date, despite the same being cleared by the respondent authorities. Correct?
9 bills cleared, Your Lordship. Of 9 bills
Out of 15.
out of 25. 9 bills cleared.
Where have you said 25?
25 number of schemes, Your Lordship.
Huh?
25 number of schemes, Your Lordship.
Okay. That way. So you had submitted altogether 25 bills. 25 bills you have submitted.
Keep walking 25.
25 number of
25 schemes. So how many bills?
bills.
That is not mentioned now.
Bills I have added, Your Lordship. And 9 bills cleared. In paragraph number 9, kindly bear with me.
You
Paragraph-
come to your synopsis. How many bills cleared?
Fifteen.
Then, now which is correct?
15. Your Lordship.
Huh?
15.
15. Now, not 9.
Not.
So you just say 15 bills there, earlier. Then you say, however, the balance amount of rupees 52,90,498 has not been paid to the petitioner. Also. Next, the petitioner's counsel submits that the petitioners had submitted representations to the authorities for clearance of their unpaid bills. Which has not been decided till date. Full stop. Next para. Mr. M. Chetia, learned counsel for the respondents number 3 and 6. 3 and 6.
Number 3.
For number 3. But 3 and 6 have submitted this affidavit. So,
Both for here.
3 and 6, submits that though the petitioners have made a claim for payment of bills for materials supplied by them for 25 schemes under the MGNREGA, no order for supply of materials has been issued to the petitioner. So further, no copy of any supply order is with the office of the BDO, South Hailakandi Block Development. No, South Hailakandi Development Block against 25 schemes. As such, the bills that were uploaded in the MGNREGA soft/website had been communicated to the higher authority for deletion. By letter dated 25/3/2019. He submits that payment cannot be made to the petitioners against unpaid bills, as no works were in the scheme and no inquiry report related to such schemes were available with the office. Next para. The council for the respondents number 3 to 6, 3 and 6 also submits that the respondents 3 and 6 have made payment
For 9 number of scheme, 15 bills.
for 15 bills. How much? What is the amount? No amount.
Amount is unknown.
Full stop. However, no hard copy of the bills, comma, requisition letter, comma, supply order related to payment lies with the office of the in-charge accountant as no records were handed over. Full stop. Where do you get the 26 lakhs?
I have been
Where?
paragraph number 9. I have
Paragraph 9.
9 specifically stated here.
Para 9 of whose para 9?
Great petition.
Read petition? No. That is, we do not know. Oh, you, according to you, you have
He
been paid.
admitted, madam.
He admitted that he has been paid.
Yes.
But then they have said that they have not paid anything.
No.
They have paid some amount. They have paid some
Some
amount.
amount.
Next. The continue the learned counsel for the respondents submit that as there are no supply orders issued to the petitioner and as there is nothing in the records to show that any such supply orders had been issued, comma, there is no question of payment to the petitioner. There is no question of payment of unpaid bills to the petitioner. Unpaid dues to the petitioner. Full stop. I have heard the learned counsels for the parties. Full stop. The petitioner has not annexed any supply order along with his writ petition to show that he had been asked to supply materials for 25 schemes under MGNREGA. As the state respondents have also taken a stand that they did not give any supply order to the petitioner, and as no records of the same are available in their records, this court is hard pressed to understand as to how the petitioner could have supplied materials to the government in the absence of any written supply orders. The same appears to be shrouded in mystery. Be that as it may, para 9 of the affidavit in opposition filed by the respondents 3 and 6 is to the effect that not para 9, sorry, para
8, madam.
para
There are 6 and 8.
para 8, huh?
Yes.
Is to the effect that the then authority had made payment for 9 number of schemes, bracket 15 bills, to the petitioners. However, comma, no hard copy of bills, comma, requisition letter, comma, supply order related to payment lies with the office. As the then in charge accountant did not hand over the records to the present in charge accountant. As the then in charge accountant, who has now been transferred, did not hand over the record to the present in charge accountant. No, not the para. Where we said 26 lakhs been given to you?
Para 9.
Para 9 of the writ petition is to the effect that the petitioners have already received part of the supply bills amounting to rupees 26,36,420. And that the balance amount of 52,90,498 has still to be paid to the petitioner. Full stop. Full stop. Thus, a reading of para 8 of the affidavit in the position of the respondents number 3 and 6, read with para 8 of the para 9 of the writ petition. No, para 10 of the writ petition. That para 10 of the writ petition implies that payment has been made to the petitioners for alleged supplies made by them. However, there is nothing to show on record by the petitioners or the state government or the state respondents that proper supply orders were issued to the petitioner for supply of the materials made by him. Yes, what is this order?
In this order, your lordship, similar issues were decided by the king.
But there's nothing here. Stop.
And the matter has been remanded to the commission.
Next para. On considering the fact that the state respondents have taken a stand that no supply orders were issued by the government for the alleged supply of materials by the petitioners. This court is of the view that no direction can be passed for payment of the outstanding amount, alleged outstanding amount, in the absence of any supply orders. In as much as it appears that the supplies have been made in violation of proper procedures. That is in the absence of advertisement and approval by the government. So consequently, this court is not inclined to pass any order in view of disputed questions of facts. In any event, be that as it may, in the event the petitioner is able to trace out the supply orders on the basis of which he has made bills for payment of his for the supplies allegedly made by him, he may thereafter submit a proper representation to whom?
To the deputy commissioner.
Case number 2 and 3.
So there's point number 2 and 3. With a claim for his unpaid bills. Full stop. The claim for his unpaid bills should have, along with the supply order, should be made on or before the expire of 2 months from today. In the event the said claim is made with copies of the supply orders from the respondents number 2 and 3 shall verify the same and take a decision on the said claim within a further period of 2 months.
3 months.
3 months. The petitions accordingly disposed of. There's nothing here, Mr. Kausar. I doubt you have got. It's basically just, he's your friend, I think, your accountant. Huh?
25 to 31.
Item?
Lordship, recollect, item number 28, item number 28, we represent. We are diploma in construction and technology. So your lordship wanted to know from them whether it is similar or not to the civil engineering, the diploma in civil engineering, because Mr. Chaudhary argued that there is a notification issued by the government saying that the civil engineering and planning is equivalent to that of the lordship. Does remember there is a notification also which they have thrown. Then your lordship said that what remains so far as that they are same, but our case we projected that they have not taken any decision. Now today we have come to know, of course, we can produce that already in person the court order. Some report they have done it, which is not in our position, of course, with the government. We have said that this is equivalent and some report are also there. This is from reliable source, but we will make an RTI subject to my learned friend as to produce that, if it is as what.
Yes, Lordship. One committee was constituted and committee gave its reports, Lordship. Therein, Lordship, nowhere it has been stated that these two courses are equivalent, but it stated that and useful in discharging duties of PWD Assam as junior engineer. That statement has been given. And Lordship, one table has also been given, Lordship.
No, you are for whom? You are for construction technology.
Construction technology.
So whether it is equivalent to civil engineer.
Yes.
That equivalent term has not
Is
been
that been used?
used.
So then what to do? Then we have got to decide.
I think I should file an affidavit and bring this report.
Report, let him furnish.
Let
We
him
will also
also
look
put-
into it. In what manner it has been described. My learned friend saying it's not similar, but some approval has been granted. I don't know. Let them file an affidavit. We'll look into it.
Is there any stay order out here?
We have 30
Yes.
out of 307 posts. Out of 307 posts, 97 posts has to be kept vacant. 97, 92, 97. 91 posts where our writ petition says that this post should be kept vacant. Mr. Chaudhary's client also said this particular case would be vacant. Ultimately 91 or 97 post is to be kept vacant. This is the case, my.
Lordship will allow me to file my one affidavit, I think required.
They should come up with the.
How much time? How much time do you want?
2 weeks, Lordship, it is.
But they
Mr.
should come with the entire report to be furnished.
He'll file the entire report.
They have already furnished.
Just one second.
You let them take a photocopy in the
No,
meantime.
I will bring it to record.
Yes. Take a photo with your phone, na?
Yes.
Mr. P. Nayak.
Yes.
Learned counsel for the PWD. Submit that he will file the report made by the,
It's a committee was constituted. Lordship.
made by a committee. Made by whom?
Lordship, a committee was constituted by the order dated 17.
Okay, sir.
It's in November 2023, Lordship. And that committee gave its report.
Okay, made by the by the committee
committee
constituted
constituted
on
on
November 2023.
And report
was
submitted on 11/1/20.
within a period of 2 weeks. With regard to the standing of the
Number of policemen here.
junior engineers, correct?
Yes, yes.
Yes.
Have a holding diploma in
Diploma in civil engineering.
construction, planning and construction,
No, say in construction technology.
in construction technology.
But this report includes all the subjects.
Doesn't matter.
No, no, doesn't, because your lordship is more
No,
concerned-
because only, we are interested only in his thing now.
But second, this part will also be required, Lordship, because one statement is there. So far as civil engineering and planning are concerned, Lordship, they appear in an examination for a total marks of 4,200. But so far as civil engineers are concerned, their total marks is 5,200. But that difference is there.
So even for Mr. K. N. Chaudhary's case, there, anyway.
One second.
You have filed an IA micro.
For?
New IAs are there for vacation of the interim model micro.
Can you hurry up with the, they want vacation also, we can.
Lordship will take up this matter after 2 weeks. Within this time, Lordship will file my affidavit. That is what.
And Lordship, since this matter is part heard,
It's not part heard, I don't know why you all put it before me. But it was not part heard, I've read it. Pointed out by so and so for petitioner that the matter was extensively heard.
Extensively is this.
Extensively.
at length.
You think nowadays,
And I thought I ran away from this case.
my lord,
You are following me around.
nowadays no part heard, it's a further hearing or extensively heard. Normally, I think bench when is.
I didn't say all that, you all said it before the last bench.
No, extensively heard.
No, you all put that submission before this other coordinate bench, and then that's why he has asked to place it before me.
May I make a submission?
If you oblige.
My lord, we have filed an IA, my lord. Now, my lord, page number 67 of the IA, my lord. IA 3731, my lord, is there, my lord. Subsequently, my lord, there was another advertisement, my lord, issued by the APSC, my lord. There, my lord, they have mentioned that candidate must have a diploma in civil engineering, civil engineering and planning. This is 2023 advertisement, my lord. 2018, the advertisement, my lord, which is concerned advertisement, it is only civil engineering. 2023, they are saying that civil engineering and civil engineering planning both can come in, but construction technology, they have not mentioned. Now, my lord, our simple submission is that once the game has started, my lord, the rules cannot be changed midway, my lord. The advertisement was clear, my lord, civil engineering, my lord. So, my lord, the other branches cannot come in as equivalent or whatever, my lord, because it was very clear in the advertisement itself that civil engineering. Now, my lord, the civil engineering.
So 23, so you have got no issue. It's already there because of that, but 2018. 18. 19.
18, right? Okay, my 19, my lord.
19.
So, my lord, when the advertisement is clear, my lord, now, my lord, we are civil engineering, my lord. We appeared, my lord. There are other branches, my lord. Now they are coming and challenging, my lord, that these are equivalent, my lord. On that ground, can they take it, my lord? And, my lord, since 2019, my lord, now we have already appeared for a Haiva versus also, my lord. Interview is done, my lord. Now,
When was interview held?
interview? In the month of December, my lord, December 2022, no? 22, 22, my lord. Now, my lord, 1 year has gone, my lord. Now, my lord, election is coming, my lord. Again, there is issue, my lord.
No, let them, Mr. Nayak is going to file within 2 weeks. Then
My
we will
lord,
discuss
can
this.
that be within 1 week, my lord? Kindly, my lord.
I'll leave it
One
calm.
affidavit, my lord.
Please get down on your knees and beg him. I don't know. Give him
Yes,
tea
my
or
lord,
something.
my lord. He can.
Okay.
1 week, my lord.
Within 1
No,
week.
Lordship will take up this matter after 2 weeks. In the meantime, if the other side have to file their response, Lordship, let them file.
No,
My affidavit plus their response on the next day, your Lordship will hear this matter conclusively. That is what I.
And I will give a reply what my learned friend has said before. Yes. What is, why he said that it cannot be compared, it is separate. My learned friend has to overcome the All India Council of Technical Education.
Anyway,
But these are education.
anyway, these issues will decide then. Now it cannot be
Yes,
decided.
that's why that if that my learned friend is that your logic can't decide. That to decide the main merit of the case, whether equivalent. Only query that was putting forward to my learned friend is that you please let us know that whether it is equivalent, similar or not. That's a report is there, let them file it, we'll look into it, what is it.
Give a date, better. 21st February,
21st. Simply,
21st.
My lord, can there be an observation, my lord, that an idea will be made to dispose of the matter on that day, my kindly.
All of you all are there. If none of you all take an adjournment, I am stuck with you all. I am stuck, I can't run away. But if you all say that, please consider, consider us for adjourning, I'll give you chance. So you make sure that none of you all ask for adjournment. If one of you all ask for adjournment, then I'll take it. I'll accept it.
My lord. Obligement. My lord, my name may be recorded in 540. Last time it was.
Okay, just right. Mr.
W.R. Mehdi.
W.R. Mehdi
Last
appears
occasion it was not recorded.
appears for
the petitioner.
petitioner in WPC number
5840 of 2020.
5840 of 2022.
Obligement.
You want your name also? Huh? Okay, you want your name. What is your name? Ms. J. Gogoi appears for the petitioner in WPC number 2064 of 2023 or 2? 3. 2023. Mr. N. Gautam appears for the petitioners in WPC number 5355 of 2022. Why do you want all your names? Okay, whoever wants their names. No, if you all want your names, no problem. Because you have got to show your clients also. It's not a problem. If they want.
Lordship, item number 32, I pray for time being, your lordship.
Item number?
32.
This is not the time for us for adjournment out of turn, madam. Just wait.
30.
Oh, sorry, this one, the
Yes.
present one. No, wait. Yeah, for the petitioner.
Yes, sir.
Who's for the government? Yes. License has been revoked, suspended. Suspended. How long can a license be suspended?
For 90 days, madam.
Then, is it beyond 90 days?
Yes, madam.
Then, do you still want it suspended, adjourned?
Lordship, I pray for time being, I need to take.
No. We'll allow your writ petition. You don't even know the law. You're not read, no? Okay, where is that? 15.2, I think, no?
Yes.
15.2. Miss
FN Jaman.
F.N.
Jaman.
Jaman, learned counsel for the petitioner, submits that where is the suspension order? Suspension order dated 14/8/2021. By which the petitioners, what? PDS license has been suspended under section 15.1.
15.1.
Correct? 15.1 of the Assam, what?
Assam Public Distribution Article Order 1982, madam.
Should be set aside. In view of the fact that under 15.2,
Yes, madam.
section 15.2,
15.2.
15.2, suspension, there cannot be a suspension of the license beyond 90 days
Without issuing notice.
without issuing notice. Any notice issued?
Yes, madam.
I don't
It was
think so.
issued, madam.
Where?
So was issued, madam.
I don't think so.
Yes, madam. 19, madam.
It is there.
Yes.
Notice issued.
Yes, madam.
Oh, yes.
Personal hearing was conducted also, my lord.
But then
whether
no
decision
decision taken.
Yes, my
So
lord.
can you still suspend for indefinitely?
Authority can be directed to take a decision on that, my lord, within a specific.
Give me the law, give me that. Something, that control order or whatever.
Yes.
Fourteen 8/21. So this show cause notice is after 90 days.
Then 12, my lord. Yes, sir.
Show cause notice on December
Yes,
and suspended on August,
14, 8.
September, October, November. Between then it goes.
Yeah.
Right. What have I said? Without issuing notice within the 90 days period from the date of issuance of the suspension order. Good stuff. Acha, prior to that, you write their names, huh? Mr. So and so, Mr. M. Chetia for
For respondent, my lord. For respondent. That's one number 1P 5 and 6, my lord.
and
2 and 4 Lordship I'll be.
Mr.
Need to for DPC. 2 and 4.
Okay. Right. Then that thing, huh? Then you write. The petitioner's case is that he is a license holder, a PDS license holder under the Assam Public Distribution of Articles Order, 1982. Hereinafter referred to as the 1982 order. Yes, sir. In view of an FIR being lodged against the petitioner, which resulted in the registration of Paneri PS case number 65 65/2021 under section 379/411 IPC read with section 7 of the Essential Commodities Act, alleging irregularities in the distribution of PDS articles, an inquiry was conducted. Full stop. On the basis of the inquiry report, the license of the petitioner was suspended by order dated 14/8/2021 issued by the respondent number 6. The police submitted a charge sheet in Paneri PS case number 65 of 2021, which resulted in GR case number 974/2021 being registered in the court of the Judicial Magistrate First Class. Where is this? Judicial Magistrate First Class?
Udalguri, madam.
Huh?
Udalguri.
Udalguri. However, the GR case number 974/2021 has been allowed to be withdrawn by order dated 10/1/2023 passed by the court of the JMFC Udalguri. The petitioner has accordingly been acquitted of the charge under section 379/411 IPC, read with section 7 of the EC Act. Full stop. Next para. The petitioner's counsel submits that while the suspension of the petitioner's PDS license had been made on 14/8/2021, no, while order dated 14/8/2021, show cause notice was issued to the petitioner with respect to the suspension of the petitioner's license only on 7/12/2021, that is after how much? 14/8, 14/31, 17 plus 6, 23. After 116 days. 115 days, right? 115 days. Full stop. As such, in view of section 15, is section or order?
Article order.
It'll be order. Article.
Article.
I'll be order.
Article order.
Article.
Order.
Order. Article order 15(2).
Yes.
Of the 1982 order, the suspension order could not have survived beyond 3 months from the date of issuance of the suspension order. Next, Mr. M. Chetia, learned counsel for the Mr. M. Chetia, just said the counsel for the respondent. But correct.
Since the so cause notice has been issued, matter of hearing has been conducted, matter of authority can take a decision, matter.
They can take a decision, no doubt, but then this thing has to go.
Yes.
Plus the criminal case is also gone.
Yes.
The very basis of the suspension order is gone.
Yes.
So, submit that they have no quarrel with the submission made by the counsel for the petitioner. However, as the petitioner has made a reply, you made a reply?
Yes.
Has made a reply dated Huh? Dated
28/8,
28/8?
23.
Huh?
28/8/23.
Where did you get that?
There is some representation to withdraw my suspension of another reply my was personally he was also whatever.
Has made a reply to the show cause notice. And has also made a personal appearance. Before the respondent number 5, correct? Oh. Has made a reply to the show cause notice, comma. Whatever I said, I have my phone. The counsel for the petitioner has submitted. Comma, the respondent number 5 should take a decision on the show cause notice issued to the petition. Show cause notice and the reply to the show cause notice issued to the petition. That's all. Should reply the show cause notice. Full stop. Next, I have heard the learned causes for the parties. Full stop. As can be seen from the documents on record, comma, the petitioner's PDS license had been placed under suspension by order dated 14/8/2021 on the basis of complaint. Then on the basis of an FIR, which resulted in the registration of Paneri PS case number 65/20. The resultant criminal case registered in the court of the JMFC Udalgiri was withdrawn on the basis of a decision taken by the government of Assam. Full stop. Full stop. The show cause notice issued to the petitioner on 7/12/2021 asking for a reply as to why the petitioner's PDS license should not be cancelled had been issued beyond 90 days of the issuance of the suspension order. Full stop. In terms of Article Order 15(2) of the 1982 order, comma, an order of suspension cannot be valid beyond a period of 90 days unless an opportunity is given to the licensee for giving reason for stating his/her case against the proposed cancellation of the PDS license. Full stop. As the show cause notice had been issued beyond 90 days from the date of issuance of the suspension order, comma, this court is of the view that the suspension order would have revived, would not have survived beyond 90 days from the date of the issuance of the same. Accordingly, now further, the reason for suspending the petitioner's license has also been withdrawn, as can be seen from the order dated
10/1/20.
10/1/23 passed by the JMFC Udalgiri in GR case number 974/2021. Full stop. Accordingly, the impugned order dated 14/8/2021 issued by the respondent number 5 suspending the petitioner's PDS license is hereby set aside. Full stop. However, as the petitioner has apparently submitted a show cause notice, has replied to the show cause notice, respondent number 5 shall take a decision on the same within a period of, shall take a decision on the same and communicate his decision to the petitioner. The writ petition is accordingly disposed of. Okay, we take this back, huh?
Money in this case, my lordship, in this case, the petitioner is the dealer of ration card holder, my lordship. So as per notification of the government, if a fair price shop having 50 or less than 50 will merge with the shop which having more than 50 numbers of shops.
Ah.
So what happened? My shop was merged with respondent number 7 shop, respondent number 6 shop, my lordship. But in my case, I have more than 50 number of beneficiaries, my lordship. I've also submitted one representation before the deputy commissioner, which is at page 17, annexure 4, my lordship.
Let us see the scheme. The tagging, where is that?
That order,
Order.
government's. That is annexure 3, my lordship, page 16.
Page?
Annexure 3, page 16, 16.
Where is the state cabinet decision for tagging of shops or having less than 50 ration card holders with another
With having
FPS?
that another ration card money.
Where is that? Where is that scheme?
This is the only, on the basis
Yeah.
of this order, they have tagged.
So you have submitted a representation.
I have submitted this along with the list of beneficiaries, which is given 67.
So
Also
so they have to take a decision on that.
Yes, they have not taken this. And also, my lordship, kindly come to my additional affidavit, my lordship. For page 55, I have given the list of beneficiaries in my shop. Up page 55.
How many are there?
Actually, there are 84 numbers are there. On record, I have shown here, I have shown 79, but actually we have 84.
Then what happened? Why are the government saying that you have got less than 50?
Respondent number 6 has given one handwritten document, which is at page of their affidavit, page 51, annexure C. On the basis of that, they have sealed. Handwritten document. Page 51 of their affidavit, page 51, annexure C. And respondent number 6, we have given notice, he has not come to.
What is this? What is this handwritten document?
That is that Therasangvi Singh by my name 50, they have given by. But actually, I have 84 number.
So they have tagged some of your customers to others.
Cancelled my stop giving any money rations to my shop. They means they merged with respondent number 6.
So you don't have a shop anymore.
No, my lordship. But actually, I have more than 84 number. I have already submitted one.
You had 84.
84 number, and this is also.
Anyway, so we'll ask them to take a decision on your representation. What else can be done?
My lordship, but
we cannot go into the questions of facts, Mr. Counsel. Whether you have got 50, 84, we don't know.
Here it is.
That evidence is required.
54, page 55. I have annex.
Maybe, Mr. Counsel, these are all photocopies. And another thing, what is your prayer in the writ petition? Please read your prayer.
Under above fact and suppose it shall be said that your lordship would please to admit this application and follow. notice call upon the respondent to show cause as if by division, natural surgery, Mendebas or any other the read order directly shall not be issued against the commanding respondent considering the representations submitted by the petitioner.
So we're allowing a prayer. That's right. Heard, Mr.
TK, my lordship.
TK, learned counsel for the petitioner. And Mr. M. Chetia, learned counsel for the respondents.
1 to 5, my lord.
1 to 5. Full stop. The petitioner's grievance is that the customers under the
Fair price. My fair price shop.
the customers registered with the fair price shop run by the petitioner has been tagged with another has been tagged with the fair price shop of the respondent number 6, on the ground that the circular issued by the respondent number 2 required fair price shop dealers to have
More than 50.
50 or more.
More.
50
More
or
than 50.
had required to have more than 50 customers.
Yes.
Full stop. Next para. The petitioner's counsel submits that the petitioner had about 84 customers registered in her fair price shop. However, the respondent authorities took out a number of the customers from the petitioner's fair price shop
Yes, 50.
and tagged them with other fair price shop and tag them with the fair price shop of the respondent number 6. As a result of which the number of beneficiaries / customers with the petitioner's fair price shop had become less than 50.
No, madam.
Huh?
This is not case, madam. His customer is less than 50. That
Okay.
is why his license has been cancelled.
Okay. Just read at the beginning. Just start from the beginning. Of the respondent number 6. No. Cut that. Cut everything. Huh? Next para. The petitioner's counsel submits that the number of customers / beneficiaries with the petitioner's fair price shop was 84.
As per affidavit, madam, it is 50, madam.
But
He
it is
requires
only
more than
handwritten document.
50, madam.
It is only a handwritten document.
However, the respondent authorities have illegally tagged the customers of the petitioner's fair price shop with the fair price shop of the respondent number 6 on the ground that the petitioner had only 47 card holders.
It is 50.
As
they
per-
take-
As per your synopsis.
Yes.
The petitioner counsel submits that the petitioner has submitted a representation to whom?
Deputy Commissioner Hailakandi.
To the Deputy Commissioner Hailakandi with regard to the fact that the petitioner had more than 50 customers in his fair price shop, and as such, his customers could not have been tagged in the fair price shop of the respondent number 6. So he submits that the petitioner's representation not having been considered till date, a direction should be issued to the respondent number 3 to take a decision on the petitioner's representation. Mr. M. Chetia, the learned counsel for the respondent submits that he has got no objection to the prayer made by the petition. On considering the submissions made by the councils for the parties, the respondent number 3 is directed to consider the petitioner's representation dated
23/3/2023.
23/3/2023 and take a decision on the same within a period of 1 month from the date of receipt of a copy of this order. The decision taken should thereafter be communicated to the petitioner. The writ petitions accordingly disposed of.
Only my thing is that they have just verbally believing, Deputy Commissioner, that verbally believing on respondent number 7, they've cancelled our shop, my lordship. Not given.
Taken care of, my lord.
Huh?
That will be taken care of while considering the.
Yes,
And
the
another-
representation will be there.
And also, my lordship.
That is your prayer, Mr. Councillor.
Yes.
We have allowed your prayer. We have not prayed for anything else.
My lords, this item 34 and 37 are connected. My lord. In the morning hours, I had sought adjournment. My lord. We have to file an affidavit. But my lord, as regards filing, my lord, the records were in this. If, in some other connected case, records were there. My lord. If you have sent back the record, we'll require 10 days time. My lord.
For what?
To file a affidavit, my lord, in a position. This is a tender matter, my lord. They have a sale settlement, my lord.
And when is the term going to expire?
No, my lord, it's a fresh. Very fresh. Fresh, my lord.
They will have stay order.
No, just a stay order. My lord. No stay order.
Okay, right. Mr. D. Goyal, the item 34.
34 and 37.
Wait, one at a time. Mr. D. Goyal, counsel for the
Forest Department.
Forest Department is granted, how much time?
10 days.
10 days time to file affidavit in opposition. This is the matter after 10 days. Give me 37.
No, 37 আছে না?
Here also.
Yes.
Okay, same order.
Yeah, paper.
Give a date.
May it please your lordship. Lordship, pursuant to order dated 5/1/2024, the respondent have filed their affidavit in opposition. Lordship, I may be allowed to file an affidavit in reply.
Miss
M. Sharma.
M. Sharma appearing for the petitioners
Sir.
is granted
4 weeks time, my lord.
4 weeks time. Is there any stay order?
No, my lord.
man.
Granted 4 weeks time to file affidavit in reply. This is the matter of the 4 weeks. Now, what is the term of this? Is there any term?
Lordship, the case of the
No,
petitioner.
there is no such term.
Okay. Next.
Lordship, kindly a date may be.
What? You're not in a hurry, madam, 4 weeks.
Keep your.
May I please, your lordship, may I pray for adjourning the matter as learned counsel is having some personal difficulties.
Are you filing any affidavit?
No, my lord, this is instructions will do. I have instructions, my lord. This person has to approach the authorities, my lord. His license was cancelled on certain grounds. But in the meantime, rules have changed, my lord. Earlier it was a hard copy, now they have to apply by this online mode.
They have applied for the renewal on 7/12/2022.
That
But
committee
they are
has
not
to sit-
accepting that.
That committee has to sit. I have a communication with him, my lords. He can be reverted back to the authority.
So let them take a decision on that. That's all. What do you want? Is there anything to challenge?
No, my lord,
This
yeah.
one, our
If they say that you have to submit an application and you have submitted an application, let them take a decision. What is there to decide? What is there to adjudicate?
they are not actually accepting our application. We have submitted it on 7/12 and they have
So we'll tell them to accept it.
Yes.
That's all. I do not know why you don't want disposal. Such a simple matter. You want to renew your stone crushing unit license.
yes, Lordship.
And they are saying, please submit application. You are saying you submitted application, but they are not accepting. We'll tell them to accept and decide. End of the matter. What more do you want? You want us to say that they should give you a approval or what? What do you want? What more do you want?
Yes, Lordship, there should be an approval by their side.
Let them take a decision first. We cannot, take their place. Tomorrow you'll ask us, you give me the contract. How can it be? Let them take a decision. What is there to, what is your grievance right now? Your grievance is that they're not taking a decision. That's all. Correct. Then- Correct. Heard, miss?
My name is not there, Lordship.
Huh?
My name is not there in the sub.
What is your name?
Yunanda,
You, Nanda, appearing for
R. Majumdar.
Mr. R. Majumdar, learned counsel for the petitioner. Also heard Mr. D. Gogoi, learned standing counsel for his department.
Online portal is closed.
Huh?
Online portal is closed. We can open it up pursuant to this court's order and.
You do it.
Yes.
Okay,
When will you open it? When will they do it?
As soon as directs us. we'll open up.
You do it, today is Monday.
10 days or 10 days or 7
By
days.
Friday, we can.
Friday,
Yes, Lordship.
Friday and Saturday, 2 days, let it be open.
Right.
Good stuff. Right, the petitioner has filed the present case on the ground that the respondents are not renewing his permit for running the stone crusher unit. Oh. Where is this order of this court?
The court's order, my lords, it's in number, my lords, page number 59 of the petition.
So out here, you have been directed to consider the submission.
No, my lord, what had happened, those guidelines governing, my lords, the system of approaching has changed.
Okay,
It's
that's
online
why,
now.
okay.
Earlier it was.
So you do it? Okay, so,
You can
good stuff.
open
The petitioner's counsel submits that this court, while order dated 1/9/2023, passed in WPC 1476/2023, had directed the respondents to consider the petitioner's application for renewal of his license in terms of the guidelines notified notified by notification dated 29/1/2023. 2003. 29/1/2003. So, sir. However, the so out here also it has been yeah, same thing, it has not been changed.
Same, my lord. No, notification is there, but the method of approaching, my lord, that
Yeah,
rules,
that is by now
that is by now online, my lord.
online. Okay.
Earlier
Earlier it was by
hand, my lord.
okay, hard copy.
Hard copies, my lord.
Now online. Okay, first step. Though the petition had submitted hard copies of the application, the same is not being considered by the respondent authorities. Full stop. Next, Mr. D. Gogoi, learned counsel for the Forest Department submits that the method of submitting the applications for renewal have now been changed, in as much as the earlier applications were made by submitting hard copies of the application form. However, the applications have now to be submitted online. He submits that though the online portal is closed as on date, the same can be opened for the petitioner to submit his application form for renewal on the dates that may be fixed by this court. Full stop. Next, in view of the submission made by the counsel for the Forest Department, Mr. D. Gogoi, the petitioner is given the liberty to submit his application for renewal of the stone crusher unit through the online portal in terms of the government notification dated 29/01/2003 on
By Friday, we can submit.
On 8th and 9th.
8th.
Which date? Which one you want?
Okay, Lordship, by 13th.
By 13th?
8 and 9, okay, Lordship, 8 and 9.
On 8 and 9 February
Okay.
2024. Time within time frame between 10 a.m.
10 to 4.
between 10 a.m. and 5 p.m. That is the application to be made by the petitioner should thereafter be considered by the
Permit committee, madam. Circle level permit committee, madam.
by the circle level permit committee. And the decision taken should thereafter be communicated to the petitioner. The decision should be taken by the circle level committee within a period of
10 days.
10 days from the date of receipt of the application made by the petition. The writ petition is accordingly disposed of.
How late?
Much obliged.
Here petitioner is a society.
We have received some comments, my lord. In fact, so we will file an affidavit, my lord.
Look, you want to run a Gaushala.
Yes,
So you let them take a decision. What is there? Have they said no?
yes, Lordship, we made representation.
Huh?
We made representation, Lordship, seeking permission, Lordship, as per the section 20 of Assam Categorization Act, there is a provision. But they did.
Why do you want to run a Gaushala?
Lordship, this is their provision, Lordship. I have a society, registered society, Lordship.
So anyway, the thing is that you want to run.
Yes.
You have submitted a representation to application to them. Let them take a decision. Why should you go to the
Otherwise,
court?
The authority, they sought some documents from the veterinary officers, from the surgeon. They all submitted their documents in favor of me. Despite of that, they did not permit me. The permission.
They did
was
not permit. No, did they reject your, did they reject your application? So we'll tell them to take a decision.
Yes, yes,
That's enough.
Exactly.
Yes, my lord.
Anna, that's all.
Yes.
Oh, why should we bother? This is not a post office,
Yes,
Mr. Counsel.
exactly.
We have also received some instruction on email, my lord. I
Ah.
have failed to, my lord, download that same, my lord.
What does it say? What does it say? Please
My
read.
lord, district authority has put the application to the commissioner, to secretary to take a decision.
That's all. Take a decision. That's all. What is this? How can you come? You're not a person aggrieved. No locus standi to file this writ petition.
No, Lordship, otherwise.
What right of yours has been violated?
No, the right of, but there is a Lordship, registered society, Lordship. There is.
Mr. Counsel,
Yes.
when you come to a writ court,
Yes, yes.
you have to come and show
Yes.
that some enforceable right of yours has been violated.
Yes.
Otherwise, you go
One-
PIL.
One thing, Lordship, one thing. Lordship, page 15 is my representation. Page
Ah.
15. This is the representation I have made. Page 15.
Huh?
Page 15.
Yes,
The representation.
yes.
And then Lordship, kindly see page 17, Lordship.
Page 17
This
is.
communication was issued by the respondent number 3 to me to follow the certain.
You
guidelines.
follow it,
Yes, Lordship, I have followed.
then
Then.
no
till
case. Heard, Mr.
the- Is it Ahmed?
Huh?
Is it Ahmed?
Is it Ahmed, learned counsel for the petition. Also heard Mr. M. Chetia, learned counsel for the respondents number 3 and 4.
One aspect.
And we have,
I have annex one order, Lordship,
Yes.
similar order.
Huh?
For 1, 2, and 5.
1, 2, and 5.
Lordship, I have annex one similar order, Lordship, which was duly passed by the respondent authorities, Lordship. Then 35, page 33. Page 33. In respect of another society, Lordship, with same relief they sought, they are given permission. It's page 33.
Let them give. What is that? Right. The petitioner's case is that it is a registered society and who has approached the respondents for running a Gaushala in the district of South Salmara, Mankachar, under the provisions of the Assam Cattle Preservation Act, 2021. The petitioners also submits that while the Office of the Deputy Commissioner, South Salmara, Mankachar District, Hatsingimari, has by letter dated 4/5/2022 asked the petitioner to submit various documents, some of which the petitioner has done. No final decision has been taken by the authorities still. They accordingly submit that a direction should be issued to the respondent authorities to take a decision on the petitioner's representation to run a Gaushala.
Yes.
Representation prayer. Puspak. Mr. M. Chetia, learned counsel for the response number 3 and 4, and no, this is Mr. Counsel for the response number 3, counsel for the respondents. Submit that. What? Any objection?
For disposal of representation matter, I have no objection, my lord. Authority has also written to the.
Submit
commissioner
that,
secretary.
submit that they have got no objection to the prayer of the petitioner. To the prayer made by the petitioner, with the prayer made by the petitioner. On considering the fact that the petitioner's prayer for running a Gaushala has not been decided by the concerned authorities, this court is of the view that the respondent authority should take a decision on the same. Full stop. Accordingly, the respondent authorities are directed to take a decision on the petitioner's request to run a Gaushala in the South Salmara Bankachar district under the provisions of the Assam Cattle Preservation Act 2021 within a reasonable time. The writ petition is accordingly disposed of.
3 months.
Reasonable time. Okay, let's. I will carry on.
Item number 49.
Just a minute.
Okay.
I will carry on.
Item 48.
Let on last occasion.
Yes, what is this?
Obtain some instruction, madam.
Lordship, I pray for some more time.
My lord, may I pray that page 30, my lord, our representation may be disposed of by the VTC authority, my lord. That may be disposed of within a time, certain time with information to us, madam. Instruction is waited.
Yes, take a decision.
Yes, madam.
Yes, ma'am. Huh? Right. Heard Mr. M.A. Sheikh, learned counsel for the petitioner, and Mr.
B. Chaudhary for BTC.
B. Chaudhary for BTC. Full stop. It is the case of the petitioner that pursuant to a tender notice dated 23/5/23, he was settled with the Katajhar market in Baksa district. The petitioner now, the case of the petitioner is that the said market should also include the sale and purchase of cattle as the three resolutions made by Mr. Counsel, what is this?
No.
Page 30, come to page 30.
Yes, madam.
This is a general meeting, you're saying.
General meeting.
Now you come to 32.
Yes, my lord. General meeting adopted resolution, my lord.
Well, 32 is executive meeting.
32, madam.
Yes, it says executive meeting.
Executive meeting regarding cattle.
Yes, and page 30 says general meeting.
Yes, my lord. That is a wrong, my lord. It should be general meeting, my lord. It is wrongly translated. General meeting, my lord. It is the translated copy of the Assamese version, my lord.
Okay, whatever I said. Should also include the sale and purchase of cattle as the general body meeting held in Katajhar market on 6/12/23 resolved that there should be sale and purchase of cattle in the market. He submits that the petitioner's representation dated
My lord, copy of that resolution was sent out. That date is.
to whom?
My lord, it's the president of the general meeting. Page 30, my lord.
Sent to whom?
Sent to the secretary, market and fair department.
So he will decide.
Yes, ma'am.
Was sent to the respondent number
4. Respondent number 4.
to the respondent number 4. However, no decision has been taken by the respondent number 4 with regard to the petitioner's representation. Bracket annexation 9. Right, close. Post of accordingly submits that a direction should be issued to the respondent number 4 to take a decision on the petitioner's representation within a specified time limit. Next, Mr. Beach Chowdhury, learned counsel for the BTC, submits that he has got no objection to the prayer made by the petitioner's counsel. Correct? Full stop. In view of the consent of the parties, comma. The respondent number 4 is directed to take a decision on the petitioner's representation. Back to annexure 9.
Annexure 9.
Within a period of
15 days.
within a period of
3 weeks. Lord.
3 weeks. 3 weeks from the date of receipt of a copy of this order. The writ petition is accordingly disposed.
My lord, a copy may be supplied to me. On that
Before
Decision taken.
the decision taken by the respondent number 4 should be furnished to the petitioner.
absolutely.
Experience.
My lord, these are those,
I know what to do. What to do?
Your worship is, already better line down to last occasion.
No, I don't remember. Now it's so much.
Some other day. Let me
We can do it some other day. I think it takes because the order will take time.
Right. Lordship, some urgency is there, Lordship, if not possible. Difficulty, Lordship, either tomorrow or day after tomorrow.
I was thinking of Thursday. I don't know. We have fixed maybe. We have a lot of fixed, no? Lot of fixed matters. No?
Let it be on Thursday.
Huh?
Because the sowing season, Lordship, for whatever crop, Lordship, only.
We can try tomorrow. Already out. Moment. They fix so many, no? They fix so many. All your cases are urgent. That's a problem. Not. Okay, Thursday. We'll try Thursday. This is the matter of Thursday. Don't fix any matters on Thursday. No. Yes.
The particular section of this IA is fine, my lord, there's an order passed by this honorable court, my lord, the other order was covered, my lord. And this was their intention, my lord. And my lord, this super, my lord, this paragraph 5 of my application, page 74, my lord. This, my lord, on the 61, my lord.
Page 74.
74, my lord.
Yes.
This 61 petitioner is only covered by the earlier judgment by different court, my lord. And 87 not, my lord. So their services after 1196, 96, my lord. So those who are before 1196, they only covered by the earlier judgment, my lord. I've annexed all the judgment also, my lord.
Huh?
I've this judgment, my lord, which was, my lord, referred by them, my lord, page 82, my lord. This was the judgment, my lord, according to this, submission was covered by this judgment.
So I've said that everyone is covered or what?
Yes, they told it was submission was everyone was covered. But so far, my lord, this I've given list also, only, my lord, 61 of the present the requisition is covered, my lord.
My lord, finally, my lord, their pair, my lord, in 70, page number 76, my lord. They're seeking modify and clarify the order. My lord, in the I perhaps cannot modify the order earlier, my lord. This is the consenting party order, my lord. My lord, they should have preferred review petition, my lord, instead of IA, my lord.
But it is there, but my lord,
No, if you do not have any objection, it can be done.
We have some objection, my lord.
Then we have got to have some hearing.
Then they have not filed objection till yet, my lord. I don't know, my lord, why, because the matter was, my lord, they registered, my lord, on this 2023, my lord, IA, my lord. And this I have given this.
What is your objection?
My lord, objection is, my lord, this is the concerning party, consenting order, my lord, earlier.
Mr. Counsel, forget about the consent. That consent can be made due to a mistaken, due to a mistake. You know, a wrong understanding of the facts or the law. So if it can be, if it can be corrected, then why not?
Because their submission was covered by the earlier judgment, my lord. So the consent was given, if it is covered, my lord, then we have no problem.
Yes.
87% they are not
You-
covered.
Mr. Counselor, what I'll do is, you think over the matter and see if that consent, just because it's a consent doesn't mean that, it has to be rigidly applied. If that consent has been made on a wrong understanding of a law, or wrong understanding of facts due to a mistake, doesn't mean that the mistake should, be held to be the rule. Should always be corrected. A mistake does not confer any right on any person.
My lord, their submission before this honorable court was Mr. A. Soikia, learned counsel.
No, let him think about it.
Whether I fix on 9, my lord, on 9, my lord.
9th, Friday. Okay, right. On the prayer of the councils, this is the matter on 9. On which date the respondents council shall inform this court as to whether no, that's all. On the prayer of the list the matter on 9. That's all. Okay.
May I feel that 2, my lord, this matter, my lord, because it may not be list, my lord.
You mentioned on that date.
Yes, I left. Wait, please, sir.
My lord, this matter, my lord, has become infructuous. Already time ago.
2018.
My lord.
Mr.
Yes, that's fine.
Yes, that's when a counsel for the petitioner submits that the writ petition has become infructuous.
Right.
Mr. S. Data appears for
1, 2, 6, and 7.
1, 2, 6, and 7, while Mr.
M. Ahmed, 8, 9, 10, 11, 12, 13, 14, 15, 16. 8 to 16.
Anybody else?
3 and 4.
Mr. M. Chetty appears for respondent number 3 and 4. As the term of the panchayat,
Yes.
as the term of the panchayat had expired in the year 2023, the matter has become infructuous. Accordingly, the writ petition is dismissed as infructuous.
Highly obliged.
43.
Wait, please, your lordship. Sir, in this case, respondent number 1 to 5 has filed an affidavit in opposition. Against that, I will file reply.
How much time?
2 weeks, my lord. In the meantime, my lord, respondent number 6, who is a private respondent, he has also filed affidavit, but no copy has been served to me, my lord.
Unfortunately, he is not here also.
Yes, my lord. And a copy has been served to her.
So you take a photocopy of her. You take, how is it thick? I think it'll be very thin. Very thin. Take a photocopy, take in your phone.
My lord.
Okay. Mr.
S. Sahu.
S. Sahu, learned counsel for the petitioner, is granted
2 weeks time.
2 weeks time to file affidavit in reply to the affidavit in opposition filed by the respondents number 1 to 5.
As well as respondent number 6, my lord.
As well as to the affidavit filed by the respondent number 6. This is the matter after
2 weeks, my lord.
2 weeks.
Because date may be fixed.
Huh?
Date may be fixed, my lord. After 2 weeks, a date may be.
You file. When you file for.
Most of it.
May I please, your lordship, as per the order of the Lauzima Court, your lordship, service is complete. The matter may be fixed for admission hearing, your lordship.
Who's appearing?
Number 1 and 2, my lord. Respondent number 3 is the main respondent.
Who is respondent number 3?
The test to municipal board, my lord.
As we appear, as notice.
Service is complete, your lordship.
Service is complete.
Yes, your lordship.
Then they are the most important.
Yes, your lordship.
Then what to do if they don't appear? Because they are the ones who have to say why they have not taken a decision on your application.
Yes, sir.
Then
Date may be fixed.
or you take the dusty service? No. Is it difficult for you?
We were permitted
Not
to
difficult, my lord,
serve
the board, my lord, taken.
We took through registered post with AD, your lordship. on 24/11/23.
Madam, you also allowed to take dusty surveys. Then you are also allowed to take dusty survey. So where is your affidavit of service? See out here. In addition, the petitioner is also permitted to serve notice through dusty by routing the process to the registry of this court. And upon service, an affidavit of service shall be filed prior to the next date of listing.
Lordship, a week time may be granted.
Okay. Miss
FN Jaman,
F.N. Zaman appearing for the petitioner. Prays for 2 weeks time.
yes, sir.
2 weeks time to serve notice upon the respondent number 3 through dusty service and file affidavit of service thereafter. List the matter after 2 weeks.
Thank you, Lordship.
Everything. Review application, my lord. Is 154 is the order, my lord. My lord, the selection process is, my lord, selections of the cow Gura, my lord. Cow Protan, my lord. This honorable court interpret my selection, my lord, only on the ground that in view of the clause G of the advertisement, my lord, the marks had not been provided to the petitioner, being the son of the earlier, my lord, Gaon Pradhan, my lord. And secondly, my lord, the petition, the respondent number, my lord, 8 in the read petition, my lord. And the review petitioner, though, my lord, resigned from the, my lord, memberships of the, my lord, Gaon Concert, but he had not resigned from the political party he belonged to, my lord. Only that 2 grounds this honorable court interpreted my lord, selections, my lord. And my lord, in the
Now he has got some document.
yes, my lord.
Some new document,
Two
Yes.
documents, my lord.
which was not there in the earlier pleadings.
And my lord, the first documents, my lord, in the repetition, my lord, the repetition has provided the final evaluation sheet. But the individual evaluation sheet that had not been provided. And that's why, my lord,
But what to do? What is wrong with the order when it was passed on the basis of the documents on record?
but on record, my lord, I have received that documents on the, my lord, RTI documents, my lord. It error apparent on the face of the record that marks has been provided, my lord.
No, that is one aspect only.
Yes.
What about that political party part?
My lord, that documents I would not place before this honorable court, my lord.
It is
that-
personal knowledge.
Huh?
Personal, what is the question of discovery of new knowledge?
Not discovery, my lord. That, my lord, I could not place because this is into misplaced, my lord.
Did you misplace?
Yes, my
Okay.
lord. That
And
is
in
the, my lord.
affidavit, he denied.
And the
But-
first part, my lord, affidavit, my lord, I have not denied, my lord. I have stated that I have resigned it. And my lord, since, my lord, I, being a, my lord, member of the, my lord, Gaon Panchayat, my lord, and I belong to a political party representing the political party, my lord. Since it is admitted and this honorable court also held that I have resigned from the membership of the, my lord, Gaon Panchayat, my lord. Since I have resigned, being a member of the political party from the memberships of the Gaon Panchayat, I ought to have been resigned from.
No, you resigned only from the Gaon Panchayat. You did not resign from the political
That
party.
documents I could not place because, my lord, I have misplaced this. That is
I file affidavit in opposition, it is not mentioned. None of the ground, my lord, in the order 47 rule 1, my lord.
It's clear, my lord, the discoveries documents is there, order 47 rule 1, my lord.
Okay, Mr.
R. Sharma.
R. Sharma appears for the review petitioner. Mr.
My lord.
Huh?
SK for the
SK
Roy.
Roy appears for
The repetition.
the petitioner and submits that he will file. What is the question of affidavit? This is a review petition.
All documents has been
List the matter on when? Next week? Next week?
My lord,
We'll dispose of on 13th.
as per direction of this honorable court, my lord, to my knowledge, my lord, no, my lord, the appointment has been made, my lord. So till then, my lord, that may be, my lord, otherwise. 46.
Yes.
This IS will file to include the successful bidders.
Huh?
Successful bidders, your lord.
Okay.
The tender was issued during the pandemic.
Who is for the state?
Irrigation.
Who is the council? Successful bidders. Yeah, you want to implement them.
Yes.
Okay, so you made a challenge,
Yes.
but you did not implement them.
Work order was issued.
Huh?
Work order was issued during the plan.
During the pendency. Oh. Okay, right. Heard, Mr.
And Talukdar.
And Talukdar learned counsel for the petitioner who submit petition for the applicants. Applicant/lead petitioner. Applicant/lead petitioner who submits that who should be implemented?
From 5 to 11.
Huh? Oh, who are them? Who are they? Who are all these persons?
The successful leader.
Successful bidders.
Yes.
In how many? In different bids.
5 packages was there.
So you were there in all the 5 packages.
Yes.
So this is in one writ petition. You're challenging 5 packages.
Yes. Yes.
Oh my God.
Tender was issued for 5 packages.
Mr. Counsel, each tender will have a different cause of action.
No, this tender was issued for 5 packages, Your Lordship.
5 packages. So each package is different from the other. Each package is different from the other or not? Look, it's like this. It's for package what? Fishery, road, what is it? Construction of a road, what is it? For fishery, market.
No, Lordship, it's for 5. It's actually drilling.
Drilling.
Yes.
So you're not going to drill in one place. You're going to be drilling in different places.
Yes.
So different contracts, 5 different contracts.
Yes.
That's 5 successful bidders.
Yes.
How can you have 5 different causes of action in one writ petition? Challenging 5 successful bidders. Basically, you want to be declared the successful bidder in all the 5 packages. That's your case.
Yes. I was deprived actually. I was, when there was an objection that I was a moderator.
We'll allow this, but at the end of the day, I think you will have to withdraw the writ petition and file separate writ petitions. I think that's a better option. Because even if we allow this, then you'll have to file amended writ petition. And then at the end of the day, when the issue is heard, there are going to be 5 different causes of action. Cause of actions, then we've had it. I can allow, there's no problem, but better, my advice is, since it's 5 different packages.
Different packages from the irrigation department here.
Maybe, you see PWD also what happened, road, construction of a road, what happened? Say there's a road 15 kilometers stretch or say 200 kilometers stretch or whatever. Then the roads are divided into 1 kilometer, some are 2 kilometers, some are 500 meters, some are 7 kilometers, some are 30 kilometers.
Yes, Lord.
And they're each given package numbers.
Yes, package.
All package numbers. It is a road. It is one road, but they're divided into different packages. And then tenders are called for each separate package. Maybe in one tender, but the tenderers are selected depending upon the package that they apply for. So if you have got a package for say package number 2 and you are selected for that, then there'll be a separate contract agreement for package number 2. Similarly, it's a different cause of action. Anyway, I leave it up to you. That is not the issue here, but that is what's going to happen.
Who may permit for individual all the.
Okay, right. Heard, Mr.
And Talukdar.
Head Talukdar, learned counsel for the petitioners. But no, applicants. For the petitioner who submits that as the petitioner is praying for being selected as the successful tenderer in how many packages?
5 packages.
5 packages. But how come the 11 persons you want to implement?
That 11% total exhausting 5 packages.
Huh?
Exhausting 5 packages. You got.
Not making sense. Okay, this Mridul Sonawal. Para 5-1. Mridul Sonawal. He's for which package? Yes, let me see the read petition. Not really.
Package number 2, you wrote.
This is item number 46.
46. Yeah.
Right. But Mr. Sessel and Counsel for the petitioner who submits that the following persons in para 5 bracket Roman 1, small, may be impleted as respondents number. There's what respond numbers?
For package number 1 to respondent number 1.
They're not making sense. List the matter.
Oh, no, no.
List the matter Thursday. Okay, Friday? No. Monday. You please look, there's something wrong with your application. How can you have 5 packages? You mean to say for some two persons were selected for 1 package? There are 9 persons, there are 5 packages. How can it be?
Okay, I will check it for on Monday.
Item? Yes. What is it?
Today the matter was fixed for consideration of my interim prayer. So perhaps
No
time, Lordship, in the meantime, the respondents have also entered appearance. The matter may be fixed, taken up for admission, where I may be granted liberty to renew my interim prayer, because that liberty was granted to me by the last one.
My lord, I'm appearing for all the respondents.
Okay, very good.
Just a while I got a written
No
petition.
private respondents.
No private respondents.
And I may be granted minimum 2 weeks time for filing the.
The time may be
affidavit of
granted, like said, matter may be taken up for admission.
Okay, heard Mr. KP Pathak, let's also for the petitioner. Mr.
N.A. Singh, your lordship.
N.A. Singh appearing for all the respondents is granted
3 weeks time.
3 weeks time to file affidavit in opposition. This is the matter.
And my lord,
After 3 weeks.
my name may be also reflected in the post, your lordship.
Registry to reflect the name of Mr. N.A. Singh.
Yes,
the
Your
causes.
Okay, that liberty may be granted to me, because otherwise I will not be able to renew my prayer on the next.
Okay, liberty is granted to the petitioner to make his prayer for an interim order on the next day. Keep your day.
Lordship, the interim prayer was to be considered after placing of records, Lordship.
I have received the record.
No time now.
Lordship, since it's a case of fraud, Lordship, maybe stay order may be granted
No, my lord.
the next day, Lordship.
Record is available, my lord.
List the matter when Tuesday. Tuesday.
Lordship.
This is the matter on Tuesday.
DPO.